Airport information mic. Wind at 320 degrees at 6, temperature 53, altimeter 3000. ILS approach runway 260. Cheers, contact clears delivery on 125.3 before taxi. Firm radar service frequency. Advise if transponder equipped. Inform the controller of initial contact that you have received information mic.
Hello, everyone. My name is Neha Singh, and I'm your moderator and host for the session. I hope you have all settled in now, and we'll be starting the session in another 1 minute. We're just hoping for everybody else to be able to join. So let's wait for another maybe a minute before we kickstart the session. I hope we have more members now and everybody has been able to join. We are on time. So let me start the session once again. For those who missed it, my name is Neha Singh and I'm your moderator and host for this session. I take this opportunity to welcome you all on behalf of Link Legal, the Campus Law Center, University of Delhi, and the co-moderator Kashish Arora. It must be a great feeling to be back on campus and in offices and to have face-to-face interactions. Please keep safe and continue to follow the COVID protocols. We are doing this workshop for an industry which is the most battered one, but still look at the potential globally and in India, that despite such challenge, the optimism is very high and so are the numbers. It's a time of very high momentum in Indian aviation. The commitment of the government is borne out by the investment being made in the aviation infrastructure, the regional connectivity scheme, the drone regulations, the PPP models, and successful and targeted disinvestments. The government has also and consistently shown commitment towards the upskilling across sectors. This workshop is actually also a big milestone in that direction. Next slide, please. The major objectives of this workshop is to provide students with an early foundation of the aviation legal framework in India and abroad, to provide applied knowledge to students through the Industry Academia Connect, to encourage wider adoption of industry-centric courses, streams by universities and law colleges. We have a much better turnaround and attendance than we expected, and we are very happy and fortunate and thankful to all of you. We have participation of students and professionals from over 12 countries and students from over 24 universities across India and overseas. The mix of professionals and students is going to be very, very interesting for this session. So we look forward to it and we hope that you have a great time during this session. I hope you have all grabbed your coffee because this is going to be a long session. Students, lawyers, and every other professional from the aviation value chain who has joined us today will have a very rare opportunity to get a good understanding of the legal framework surrounding aviation. And students could use this to start building their expertise early on. We are also happy to offer to the students, in particular, a certificate of participation, which will be awarded on complete participation of this 2-day workshop. For select few students, Link Legal is also happy to offer an internship program. For details, the students are requested to go through the brochure and write to us in case there is a difficulty. The day 1 session, as you can see on the slide, is laid out very briefly. The idea is to aim at providing the aviation outlook followed by the basic domestic legal framework and international conventions surrounding and impacting aviation in India. The day 2 session would be focused primarily on the contractual side. The workshop has been months in making, no less than 6 months, and we feel very fortunate to have great partnerships and collaborations. We, of course, could not have asked for a better lineup of speakers, where each one is an authority in their own right. We will, of course, be making detailed introductions in accordance with the session. We at Link Legal are very proud to be hosting this event, and I'm personally very thankful to the leadership at Link Legal to have supported this in letter and spirit. With that, I would now like to invite Professor Alka Chawla to give the welcome address. Professor Alka Chawla is a PhD in copyright law from the University of Delhi. She teaches intellectual property, administrative law and jurisprudence, and has keen interest in gender studies. Professor Chawla has authored 2 books on copyright law, Law of Copyright Comparative Perspectives, Copyright and Related Rights, National and International Perspectives. She is the author of a well-acknowledged report on counterfeiting and piracy in India, which was an OECD project. She is nominated as a national expert on intellectual property by the European Trade and Business Council, mentor to the Intellectual Property Protection Organization, advisor to National IP Organization, and member education committee of FICCI. Professor Chawla has delivered lectures at various prestigious institutions and universities like the George Washington University, the University of Edinburgh, ESCP Paris, Swiss Institute of Comparative Law, the Indian High Commission London, Indian Law Institute, FICCI, and various judicial, police, and customs academies throughout the country. She has also been the recipient of the Teacher of the Year Award in 2018, given by the Indian National Bar Association. She also featured in the Top 100 Powerful Women in Law list released by the IP Forum in 2017 and again in 2021. I have personally been a student of hers, and I take immense pleasure and pride in inviting her today to address the session. The floor is yours, ma'am.
Thank you so much, Neha. Am I audible?
Yes, ma'am.
Okay, thank you. Very, very good afternoon to Mr. Atul Sharma, Managing Partner, Link Legal, Neha, all the speakers and collaborators, our erudite faculty members, my dear students, ladies and gentlemen. I, Professor in charge of Campus Law Center, welcome you all to participate in this international workshop on laws governing aviation in India. As Neha said, this has taken 6 months. I remember the first day when Mr. Atul Sharma talked to me regarding this. I was very excited because this is a subject which is not taught in our center. And I found out meaning that, we come to know that India is experiencing an unprecedented growth in the aviation sector owing to rising middle class, its increasing dispensable income and economic growth. India has emerged as the 3rd largest domestic aviation market in the world and is expected to overtake China and United States in the near future. At the backdrop of the civil aviation industry emerging as one of the fastest growing industries in the country during the last 3 years, it becomes pertinent to be aware of the laws governing the aviation sector in India. And for this, I'm very thankful to both Mr. Atul Sharma and Neha for organizing this for our students. As I was going to read out the objectives of this workshop, but they've already been given to you by Neha. But just again as a repeat, we basically want the students to participate right at the early level so that they can actually participate in the both the theory and the practice of the aviation laws. And I think they should not be far when we in the Campus Law Center at least should think of providing it as an elective. And since you have so many specialists coming here on the workshop today, we would in fact want some kind of a collaboration if we can work on, some more, say a 7-day workshop or something like this. As you're giving certificates for 2-day workshop, we can have a larger, we can talk to the university for some certification or a diploma. So we can work on that. Because as you all know, Campus Law Center is the pinnacle of legal education in India. It has produced a number of luminaries and stalwarts in all walks of life. And Mr. Atul Sharma and Neha being the 2 right in front of you, including judges of the Supreme Court, High Court, political leaders, ministers, policymakers, academicians. CLC is pioneering the legal academics through case study-based learning method. And this peculiar method, case study method, I would say, it bridges the distance between a classroom and a courtroom. And you will find anywhere, if you find a CLC graduate, you would find that the person is a mix of both academic prowess and practical genius. And most of them, I would say, some delinquents you will find everywhere in divergence. But most of these CLC students you will find are passionate, they're rooted, they're market ready, and they don't carry the burden of legacy. Rather, they adorn it with pride. Today, as CLC adds yet another feather to its cap, we are glad to partner with Link Legal, a global leader in the field of aviation law practice. In fact, I would very proudly say that Mr. Atul Sharma's 2 sons are also from Campus Law Center. And I think the entire family can vouch that every now and then there are people like them who are adding feathers to our cap. This 2-day workshop, it would be addressed by erudite speakers, as Neha has already told you. They have profound knowledge, understanding, and experience in the aviation industry. In the end, though not, as we say in the last but not the least, I would like to congratulate Dr. Seema Singh, who's the convener of the Debate and Discussion Society, who's organizing this with Link Legal, and all the students who are instrumental in organizing this workshop along with Link Legal. I'm hopeful that all these sessions would invigorate novel perspectives about the scope of corporate law and bolster a new discourse. I'm sure the students are going to be benefited by all the discourses. I once again welcome you all. Thank you so much, Neha. I hope all these sessions would be benefiting both the speakers and the listeners as well. Thank you and all the best.
Thank you so much, ma'am. Thank you for these kind words. And absolutely, we have to take it forward in multiple forms to be able to benefit, like you said, the speakers and students alike. There is a long way to go. Thank you so much for this address.
Thank you.
Move on. Thank you, ma'am. We move on to our first speaker of the day. Mr. Ambar Dube is the Joint Secretary of Ministry of Civil Aviation and the Vice Chancellor of Rajiv Gandhi National Aviation University. He's an alumnus of IIT Bombay and IIM Ahmedabad. He was one of the 9 professionals selected in September 2019 by Government of India to join as Joint Secretary in the Union Government. Mr. Dube was a partner and head of aerospace and defense sector at global consultancy firm KPMG. Mr. Dube is the co-chair at US-India Business Council, American Chambers of Commerce, and a member of the aviation committees of FICCI and ASSOCHAM. He has worked closely with the Ministry of Civil Aviation in drafting the Vision 2040, National Civil Aviation Policy 2016, and Policy Framework for Regional Connectivity Scheme. He also helped the Ministry of Civil Aviation in drafting the 12th 5-year plan of aviation. Mr. Dube has been honored repeatedly for valuable contribution to Indian aviation. He has been instrumental in facilitating the growth of the fast-growing drone manufacturing industry in India and making India a drone hub by 2030 through the liberalized drone rules, airspace map, the PLI scheme, the single window digital sky platform, and the drone certification scheme, not to mention the National Air Sports Policy, which was published very recently in January 2022. This session, after a brief introductory note, would be conducted in the form of a Q&A session, and the attendees are motivated to ask any questions that they have about the drone sector in RGNAU in the Q&A section. Before going on to Mr. Dube, I would like to hand over the mic to our managing partner, Mr. Atul Sharma, who would like to speak a few words about Mr. Dube. Over to you, sir.
Thank you, Neha. Well, if you look at the program, there's no such slot given to me to say what I'm going to say now. But I would be failing if I don't say something about Mr. Dube. For us, he's Ambar, because he is one person who's first a professional and then a bureaucrat. But the best thing about Ambar, as I may take the liberty of calling him, is the fact that he has chosen a path after being in consulting and having dirtied his hands at the KPMG and other consulting outfits as a consultant. He has chosen to move to a role which is of an implementer. And because we have always, as professionals complained that, there's so much that is discussed in terms of what the sector should be doing, but its implementation is a far cry. So that's very creditable. And I'm indeed delighted that we have Ambar today, his expertise available in the field of aviation. He has spent his entire life, most of his life, working on the aviation side of the business as a consultant. And now, of course, he has chosen to be a part of the policy making system. So I just wanted to say that and thank him for being here. And I'll hand back to Neha.
Thank you so much, sir. Thank you so much for joining, Mr. Dube. The floor is yours, sir.
Thank you so much, Neha and Atul ji, for this great honor. It's always a pleasure to interact with young minds who are going to be the future of India. And last time when Neha came to the ministry and we were discussing the format, I requested her, if we can actually make it interactive, because the last thing you want is on a Tuesday afternoon is to be bored to death by some babu going on and on about how we're going to change the world. So Neha, would you like to throw some 2-3 questions, and then of course we can take, there's some, I'm actually scared to see 398 participants. This is all your what do you say, charm and what do you say, pulling factor, you and Atul ji and Link Legal and of course Campus Law Center. 399, we may just hit the 4th century, and it's actually scary to be have so many sharp people watching us. But I'll try and, to the best of my ability and honesty, try and answer as many questions as I logically can. So, and keep the focus more on drones, because some of the other aviation areas, of course, aviation is such a great sector. It's our first love, and it is such an exciting field that you can spend the entire afternoon just discussing about it. So Neha, just to get this thing started, can you throw some 2-3 questions, some random questions that don't have to be in a particular sequence or something?
Yes, sir.
And also, let me tell each of the 4 or 5 people is now, the number is just climbing up. Okay, all 400 people, there's nothing called a silly question. So please feel free to whatever you may think. Don't worry about what Neha and Atulji may think. Just ask some silly questions also, because sometimes the silliest questions are the ones which actually make us think, and some great ideas come from those silly questions. Neha, over to you.
Yes, sir. Absolutely. Thank you so much, sir. So let's start with, the benefits that the drone technology brings into the sector. Obviously, the drone technology has the potential to affect every market segment in India, whether it's last mile delivery to medicines to agriculture. But what is it that you see in a longer run? Because this is something that is currently being perceived by, I think, multiple nations. How is it that we are going to keep our edge when it comes to this sector? And what is it that you foresee personally in terms of implementing it to the benefit of us, and where we keep the edge always as a nation? Because we have started very early on in the drone technology and regulatory side. We have done multiple right. When it comes to ticking boxes, I think we have ticked almost all right boxes when it comes to regulatory changes, right kind of tech, policy initiatives. So what are your views on this?
Sure. Or be there for chat box, maybe there could be some more questions.
Yes, sir, there are many. So you want me to throw them all to you right now?
हाँ, एक साथ बता दो, सब पैसा वसूल हो जाएगा तो.
Okay. So how has the union budget boosted the growth of the drone industry in India? The next question, which seems interesting, is what are the considerations when we make new laws about drones? Which I assume would be meaning that if in view of changing technology and in the times to come, do we foresee changes in the drone regulation? And if we do see that, what would be the criteria around that?
एक last ले लो, फिर उसके बाद then start answering them, and meanwhile all questions आएंगे तो then in the second phase.
One more is that how do we envisage stopping the misuse of drones, and what is the objective of the drone certification scheme?
Okay.
Yeah. I have a couple on, sorry, go ahead.
हाँ, बोलते हो, because जितना एक साथ होगा ना, then as I said, it becomes interactive. Otherwise, it's very boring to listen to a babu.
Yeah.
I can be very verbose and I can bore you to death. Okay, so statutory warning like you see on every sutta ka
No,
packet.
not at all. I think the students here would be more than delighted to know more about drones. They are more the people of today. So I'm sure every word that you say is not going to be, missed. So our next important question, sir, that comes here is, what about the privacy of individuals in a time where drone technology is getting increasingly advanced? Of
Good
course,
question.
yeah. How long, in your opinion, would the indigenous manufacturing of drones take in India, particularly the heavier ones that could carry cargo or passenger, etc.?
So आपने उनको prompt करके रखा है या these are some very intelligent questions यार. I thought people
There are 400 people and there are so many more questions. If you have time, we will take them up.
हाँ बताते जाओ चलो. Make in India हो गया. Yes.
you thought that students we professionals only know what we know. They are much sharper than us.
Absolutely, and we are in good hands. It seems our future is in good hands. हम लोग तो अभी retire होके चले जाएंगे. चलिए नेहा.
Yes. So one more question. Last question is, what is the contribution that RGNOU is making in various fields when it comes to aviation and law, and how, as a law student, do we, connect with RGNOU and, enhance our career opportunities with RGNOU? So with that, we can start, sir. If you have any time left after these questions, we'll be happy to pose more because there are many coming in.
Okay, so I have a hard close at 4:30, so that gives us about 35 minutes. I'll try and give very short answers. Okay, let's do it a little Arnab Goswami type nation wants to know kind of a thing, so that we can take in more and more questions, okay, rather than giving a long speech. Okay, so what I'll do is maybe I'll start with the easiest question which Neha asked, which is the first question. What are the benefits of drones? The sweetest and shortest answer is that I tell the 417 people now, you tell me an area where drones cannot be used. Okay, and I'll give you an extra, maybe chole bhature at Gulati's, very oily, spicy chole bhature at Gulati's. If you can tell me one area where drones cannot be used. Okay, so you name a sector and it's got use. It's nothing but eyes, ears, limbs in the skies. Okay, and when you have eyes, ears, and limbs in the sky, I mean the potential is just unthinkable. It's almost like asking, when we were kids, like in the 60s or 70s, or in the 90s, about the cell phone, and today when the cell phone and the internet has got together, okay, and with a camera and a music system also thrown into that phone along with some 10,000 other apps, okay, none of us in late 90s could have imagined where cell phone technology would be, okay, or where internet would be, and what all uses where some of the applications that we do today, we can't think of life without the phone. This was not the case in the 80s and 90s. So drones are going to be just like that. They're going to be like the phone and the internet. Everybody will have a drone or drones. Okay. So now comes to key areas, of course, from the government side. See, what is the government's role? Our job is to basically govern national security, currency, foreign relations, and public welfare. And the last part, public welfare, is our key focus. In fact, what the other the things I mentioned, governance and all that, also is linked to public welfare. So our focus is not on pizza delivery. That, of course, Domino's and Pizza Express will find a way. They are corporates and they have deep pockets. They can find a way. But our role, our key interest is in the farmers. Okay, there's some 6.6 lakh villages. These are the guys who put food on our table. That beautiful lunch that we had and the dinner we'll have tonight is provided by these guys. So and they don't have any tech support far away in the villages. So agri drones, and there's almost a revolution that can be created by agri drones, and we'll come to that when we talk. Somebody asked an interesting question about the union budget. So agriculture, okay. Then there's search and rescue. When you have the Kerala floods, or we have so many natural disasters, cyclones in Andhra or Odisha, or the river flooding in UP, Bihar, or Assam. These are almost like an annual or once in 2 years kind of phenomenon, and they're not every place you can send a helicopter. Okay, of course the NDRF and the Navy, Army helicopters land up and they do a fantastic job, but you can't have hundreds of helicopters. They could be 2, 5, 10. They are limited. But drones, you can send hundreds of drones out there and get an absolute real-time situational awareness, and then based on that, then you can send the helicopters. Even on a marooned family, a family which is marooned on top of a kacha house or a pakka house, and there's water all around. Now, normally, how do you throw the food packets? You normally chuck them from a helicopter or even a fixed-wing aircraft which moves at a very high speed. which a drone, and a lot of those food packets actually fall in the water, get damaged or get soiled, or they just burst open and stuff. And not many people can actually go and swim and pick up a packet. That packet is lost. With a drone, you can do pinpointed delivery right in the hands of a person. Okay, there's another big revolution which is happening, and I'll stop there because I don't want to go on and on about the various government schemes. Okay, but this is almost like a revolution brewing in our villages. There are 6.6 lakh villages. I'm sorry to repeat it, but there is a Swamitwa scheme. I mean, it's as a full form survey of village areas using IT and stuff like that. But basically, in every village of India, every property is being mapped through a drone. And then the Patwari, along with the land revenue officials, I mean, they put a white chune ki line around the rural property. Then they radio the drone comes and flies and takes a picture of that whole village. Each property, each corner is then geotagged, okay, to the 8th place of decimal. And then once it's verified by the government, it becomes part of a government property database, just like your Aadhaar card. Okay, so once your this thing becomes part of the government database, you're issued what is called a Swamitwa, your property card, and that property card will have the photograph, the GPS coordinates of the 4 or 5 or 6 corners of your house, okay, and all your other details, Aadhaar card, name, and all that. The beauty of this card, just like your Aadhaar card, is that you can simply just tear off the property card or burn it. Okay, because it's already part of the government database. Now you can use this property card, or even if you just land up in a bank and you just give your Aadhaar card number through the Swamitwa database, the banker can automatically get access to your property details. And then you can buy, sell it. I mean, you can distribute amongst your 3 daughters. Okay, or even if there's a land acquisition happening, some road project happening, there is a proof of ownership. Because I could be in the villages, living in my village home for say 10,000 years, but I don't have a property paper like you have in the urban areas. Your parents would have property papers. So this is a revolution which is happening very quietly. Not much is spoken about it, and we've been given exactly 5 years to do that. 6.6 lakh villages, and you'll be surprised to note that on 31st of January, I'm told 36 lakh property owners have got their property cards in the villages. 36 lakhs, that's 3.6 million people have already got it. So it's not just a scheme, grandiose scheme being talked about. So, and there's, I spoke about search and rescue, also medicine delivery. You may have seen that in the remote areas, in the hill areas, it's so difficult to go from hill to hill. Now your primary health center or the government hospital could be in one place, and the other place could be, as the crow flies, it could be just 1 kilometer, 2 or 3 kilometers. Okay, but to get to that hilltop or go to that village, sometimes it would take 2 hours, 3 hours, 6 hours, or maybe the entire day. In case of a snake bite, I mean, even to bring the person to the nearest hospital may take 3 hours, 6 hours, 8 hours, the entire night. Okay, and the person might, or even if it's an accident case, the person may die just on the road because of the sheer vibration that's happening in the rickety vehicle that he might be traveling in. Okay, but with a drone, that distance of 10, 20 or 30 kilometers can just be covered in say half an hour or an hour, depending on the speed of the drone. And you can actually deliver medicines and say a snake bite serum or whatever. Okay, it can even pick up blood samples and bring back, and you can do the analysis and tell the person what medicine to have. So I'll just stop here. I don't want to go on and on. As I mentioned, there is absolutely no area where drones cannot be used, because these are nothing but eyes, ears, and limbs in the sky. Next, I go to Neha's question about what kind of an edge do we have. Now, please note that just like your laptop or your phone, the beauty is that the physical part, because the physical part which you hold, okay, the drone is like a small toy or a big toy. It's a physical product. But the value of the physical product is just about 20 to 30%. Almost 70 to 80% of the value comes from the intrinsic, the software, which has gone into the drone. Just like your laptop. In your PC or your laptop, the physical part is only 20, 30%. And 70% is all the licenses that say Dell or HP or Apple or whichever PC or laptop you use. Almost 70 to 80% comes from the software licenses which go into that, the IP part. And this is something which Indians are good at. Okay, we are global champions in software. Hardware, may somewhere we missed the bus. And our friendly neighbor up north, China and Vietnam and some of the Southeast Asian countries, they stole a march over us. Okay, so there is a gap, and inshallah on the physical side, on the hardware side also, we'll catch up through the PLI scheme that Neha spoke about earlier. But on the software side, we have huge potential, and that's where our strength is, and that's what will propel us forward. And the beauty of this is, I mean, if you're doing an agri drone, okay, something which does say crop assessment, just by looking at a field, it can just take pictures, and based on the color green of the leaf, I can actually tell you where to, not me, it's the software which will tell you where to put urea or potash or NPK or just this natural manure, or maybe more water or less water, or do pesticides. So this kind of software, okay, converting the color green, or even in the 4th week, 6th week, just like you track baby's health, you can actually track the plant. The plant is also like a baby which will grow into a bigger plant and then yield the flower and the fruit and the harvest. Okay, so all that crop prediction and assessment and doing precision farming, which means the drone will actually help you, will tell you where to put exactly what in what quantity. Today, what the farmer typically does is that 10 generations of information that he has, that native knowledge that he carries, which is fantastic. Okay, but even to spray, you might have seen in videos about what is called spray and pray. So he'll basically take a bag of urea and start spraying it around. Or maybe he'll put that backpack on, and in case of a pesticide, and start pumping it with his left hand, and with the right hand he'll keep spraying. Now this is so dangerous to his eyes, ears, his skin, his lungs. Okay, but he has to do it because there's no other way. So with a drone, all you can do is you just feed in the coordinates of your farm, of your the acreage that you have, and the drone company itself will help you create. I mean, in fact, there will be software which will help you create a serpentine path. So it'll go left, right, or basically forward, backward, go up to the end of the field, take a U-turn, come back, and then again take a U-turn, then go back. So he can do up and down, back and forth, and in exactly 7 to 8 minutes, you can clear an acre of absolutely fine spray, absolutely of the same uniformity. There's no spray and pray here. Okay, it's only spraying and perfect spraying. And we are told this is very sustainable because it cuts down almost 70 to 80% of the water which is used. It cuts down almost 20 to 30% of the fertilizer cost. And the fertilizer cost is a cost to the farmer as well as to you guys, okay, and to your parents who are the taxpayers. Because if you know, some 70, 80 or 90,000 crores worth of fertilizer subsidies are given, okay, every year, so that the fertilizer can be made cheaper. So this is, as I said, just one use case. And in the union budget, if you notice, like most ministries send a long list of wish list to the finance ministry and to the PMO. And what happened was that in case of aviation, again, as usual, this tax break, that tax break, this help, that help, all kinds of things we wrote. The only 4 things that Nirmala ma'am, the Honorable Finance Minister, picked up were just 4 things. And they were all about drones. So she spoke about drone as a service. She spoke about Kisan drones. She spoke about ITIs. In every state, there are hundreds of ITIs. Some of them will pick up and start drone training. And she spoke about drone Shakti, and she spoke about the agri drones, as I mentioned. So in the union budget, I mean, what we're doing is anyway we are going to do, but the budget is also maybe a very powerful indication of the vision and the thinking of the government going forward, because it doesn't talk numbers, because numbers anyway, whatever we want, there's a separate process, and we'll get a budgetary estimate and then a revised estimate, and we'll get the funds allocated. But if the Honorable Finance Minister on the floor of the House in a budget speech, when she mentions agri drones almost 3 to 4 times, you can imagine the message goes down across the government. Then the next question was about new laws and what are the key considerations. The key consideration is very simple: national interest and public welfare. Okay, anything which is not in the national interest or which is not for public welfare, okay, is not a great policy. And we do make mistakes. Okay, in fact, there's a live case here. We actually came up with the drone rules in March of last year, March 2021. And lo and behold, 5 months later, we repealed the March rules and brought in the new drone rules, much more liberalized drone rules in August of 2021. That's precisely 5 months. This must be like a world record in making a law and then repealing the law and then coming up with a new law. Okay, and especially this government, it's not famous for repealing laws. Huh? It brings in laws based on ideology, based on thinking, based on feedback, or whatever be the considerations. Okay, and it is not famous for, and it's brought in lots of very, very strong legal changes in the last 6 or 7 years, and none of that is repealed, even if there's whatever protest you may do. So I don't want to get too political here, but let's just say, the evidence is that in 5 months, in fact, not in 5 months, 5 months before it was released, which means within 2 months, we got the marching orders, right? Okay, based on our feedback. And this again shows a very healthy, healthy cooperation and coordination between government, the regulators, DGCA, BCAS, Home Ministry, the industry, the young startups, and the academia, the IITs and Indian Institute of Science and the various triple IITs. Okay, the feedback was so harsh on us because see, laws, as you know, all students of law, you know that laws are always made in a context. Okay, so maybe I don't want to get too say controversial, but the sati pratha or the sati law might have come sometime in way back in our by our ancestors, and then it was repealed. Okay, and then so many child bride laws, there's so many laws which you might call absolutely unacceptable today. Okay, even on the gender laws and 377, I'm not a big expert on that, but lots of sensitive areas where there are laws. Laws are always made in a context. Okay, and as the context changes, the laws have to keep pace, and the only consideration has to be the national interest. And in the national interest, sometimes you may hurt the citizens' interest in the current times. Suppose we decide that in the national interest, we may have to raise GST rate by 2%. Everybody is going to cry about that. Nobody likes paying taxes, especially a lowly paid babu like me. None of us, they say taxes and death are the only realities. But suppose in national interest, we have to increase the tax rate by 2%. So we'll all hate it. It will be against the interest of the current taxpayers probably. But maybe if that money is better used, okay, it may be in the long-term interest of the nation later. Suppose sometimes the environmental laws, many of you must be becoming experts who might be very ecologically sensitive, and you might be thinking of a focus in environmental law. You know that sometimes factories are disallowed, mining is disallowed in the name of environmental laws. Airports, the Goa airport, the new Goa airport in Mopa, was the construction was shut down because of some issues with the environmental clearance that was given. So maybe you're hurting the current population or the current project proponents or the current government, but it could be in the long-term interest of the nation. So it's always national interest which drives. So same thing happened in the case of drone laws also. And as I mentioned, in 5 months, if you could repeal a law by a government which is not known for U-turns and repealing laws, just shows that they had the humbleness. We had the humbleness to take the feedback. And also, as I mentioned, it's done in a context. So in 2019 and 2020, you did see that there were lots of drone attacks. There was a Saudi Aramco strike. There was some Iran strike. Lots of incidents in, say, Afghanistan and Iraq. So somewhere the government got, a little tilted towards the safety and the security side. And that probably brought in so much of checks and balances in the drone policy that when the industry saw it and academia saw it, they realized that, boss, this is going to bite, and this will actually kill innovation. This will actually enhance imports, because if you can't make a drone here or fly a drone or test a drone in India, and you're going to go make us fill so many forms, etc., and pay so many types of fees, innovation will not be happening here, and it'll actually help, hurt this industry and help our enemies. And we realized that, and also drone industry, let's face it, these are not a vote bank. So it's not that, you can win a Punjab or a UP election by improving the drone laws. Okay, so drone laws, it just shows the power of the technology was so huge that it forced the government to accept its mistake, have the humbleness to accept it, and then redraft it, going through public comments, then again to law ministry, and then getting it cleared by them. Then the Hindi anuvad goes for law ministry approval, and then finally it's notified. And all this was done between 15th of June and 25th of August. Okay, so that answers the question about the new laws and the key considerations that go behind it, even in writing a law and versus repealing or taking a U-turn on a law in national interest. Next question was about misuse of drones. Of course, as they say in crude Hindi, there's chaku hai. Chaku se sabji bhi katti ho, gale bhi katte. Okay, but what kind of restrictions do you put on a chaku? Now, you can't just put a requirement of an Aadhaar or a passport every time my mom goes to the market to buy a knife. Okay, so there have to be reasonable restrictions, and that's why, as I said, in the previous US rules, the drone rules, there were too many restrictions. And then finally, after a lot of debate with the 2-letter, 3-letter agencies, IB and MHA and Naval Intelligence, Army Intelligence, there are lots of security considerations. Based on that, we came to some kind of a compromise. I can't share all the details, but like in the forms you would have seen, now passport is mandatory. Okay, so because earlier, even to own a drone, you need to have MHA clearance. And MHA clearance can take anywhere from 2 months, 3 months, 6 months. Now we cannot, suppose we want to have 5 lakh drone users or 10 lakh, a million drone users. Do you think that the Home Ministry can handle 1 million security clearances? I mean, you'll become a grandfather or a grandmother by the time your turn comes for a security clearance. So we found it was completely impractical. So the compromise was that we'll ask for a passport and Aadhaar, and that is good enough. Plus, all the intelligence agencies have access to all the databases that we have. So all the drone owners, the type certificate owners, the guys who do drone flying, okay, the flight path clearances. So the nodal officer in MHA, MOD, and some of the security agencies, they have a direct access, including the police, the nodal police officers of each of the 28 states and union territories, and all the armed forces and their intelligence agencies, they have access to the database. So, I mean, you're saying, I mean, let the show go on. And if you have any issue, I mean, you have access to the entire database, the flight path, anyone flying in the yellow and the red zones, okay, which are restricted zones. You can always do a investigation or a pre-event or a post-event investigation in things in case something goes wrong. And as regards permissions, we said no MHA clearance and no police clearance required for any license or certificate that we give out. A passport is good enough because the passport at least ensures there's one police visit to your home at least once in 10 years. So we thought that's a good enough way. Let's start. Let's take a leap of faith. And if there are not too many incidents, because this came in August, so it's been 6 months and we haven't heard of any major event or incident. And God bless, I mean, touch wood, it's not happened, and I hope it shouldn't happen. And in fact, the Jammu incident, when it happened under the old laws. And that allowed us to counter the argument. It's a very strong legal argument that the Jammu incident where at the Air Force Station, we had 2 grenades thrown by a drone. I mean, that happened under the old rules. The simple fact being that each criminal by the very nature, I mean, his very behavior is a criminal. His job is to break the law. So any law you make, whether you ask for passport and Aadhaar or driving license, doesn't really matter. Because he's going to anyway assemble a drone quietly using like a bomb. He's going to just watch some YouTube videos and the parts are easily available. You can always make a drone and break the law. So why punish a nice guy like Kashish Arora or say Neha Singh, okay, and harass them before they can actually fly a drone? The other big change was that up to 400 feet, we have completely deregulated Indian airspace. Okay, other than some 4,000 red zones, which comprise, I mean, it's very less. Almost 90% of India is now declared as a green zone. The airspace map is freely available on the website. There was a lot of debate on that also. But even that airspace map is now freely available. So you don't have to do any login, ID, password, OTP or something to access India's red zones. Of course, it's a low resolution map cleared by the MOD and MHA, but it's freely available. And there were questions on law saying, I mean, are you giving our Chinese friends or Pakistani friends, our red zones on a platter? And then based on a lot of debate and discussion, we finally agreed at a particular resolution that these don't tell you anything. In fact, there are far better resolution maps available freely on Google Maps. So what are we trying to avoid? But at least the drone operators now know where the red zones are. So whenever they design a flight path, these are low resolution maps, but they get to know where there's an atomic plant or a nuclear power plant or say a military zone or a cantonment and some sensitive areas within the cantonment. Don't fly there, rest of the places you can. So that becomes a big help for all the law-abiding drone operators in the country. Okay, so this was on the misuse part. So we have simplified the systems a lot, but also given access to the agencies to all the data that we collect from the users who fill up the forms. Then there was about certification. Certification is very simply that, I mean, anything which flies in the Indian airspace, because it may fly over what you call Papa Bravo Victor, people, buildings, vehicles. So, I mean, that item has to be airworthy. You cannot just allow anything to fly in the airspace, okay, which is not certified. And that also has been made very simplified now. There is QCI, Quality Council of India. It comes under, it's a government body, but it's an autonomous body. Its head is actually selected by the Prime Minister of India, Mr. Adil Zainul Bhai. And these guys, and as per the rules, they have 60 days. So when you design a new drone, suppose you're a drone company and a drone manufacturer, you design a drone and you send it to the labs of QCI. They have some empaneled labs. They look at your drone and go through a standard checklist. And within 60 days, they'll tell you whether it's an accepted or not. It's very similar to the motor vehicle concept, where whenever a Maruti or Toyota or a Mercedes comes up with a new vehicle design or a new type of vehicle, they take it to the agencies. They actually type certify. And once it's type certified, say Maruti Shiaz, then Maruti can keep on building Shiazes as many as they want, thousands per day, without any check from the government, just based on a self-declaration that this car actually conforms to the type certificate issued to. Now, if they change the suspension or the gearbox or the brake system, of course, they have to go back to the authorities to get the type certificate. So once you have the type certificate on the drones, you can just go to the Digital Sky platform, which is a single window clearance system. And as a manufacturer, you can generate your own registration number for hundreds of drones that you produce today, just like the automobile sector. So if Kashish is manufacturing drones, he has a type certificate. So of the same type, he can produce hundreds of drones today. Go to the site, put in the serial number of each of those drones, and the system will generate its own unique identification number, which is like your vehicle registration number. So now you don't need to come to DGCA like in the past or the ministry. Okay, so it's completely made automated. I saw some question in the chat box that which is the agency. It's called QCI, Quality Council of India, and I mean, it's all available on Google. Just type in certification of drones, QCI will come up. Also, our drone rules. This is another big thing which we did with a lot of help from a very smart lady and very hardworking, committed officer called Ms. Veena Kothavade. And Veena ji is a Joint Secretary in Law Ministry. If you notice the drone rules, these are just 11 pages, just 11 pages. And another thing you'll notice, now this comes to the law drafting part. We were told, right, by the highest authority, in fact, from the PMO itself, that keep the law simple, because laws have to be, as I said, developed in context. They have to be developed keeping the end user in mind. Now here, the end user startups, they are not like our other end user like Indigo or SpiceJet, where they'll have a whole army of highly paid lawyers or as an employee or as their legal advisors who can give them advice on all kinds of laws and rules and Aircraft Act and this act and taxation and all that. These are startups. Many of them have just 4 employees, 5 employees, 5 kids got together in the 4th year in engineering, and they set up a startup. They don't have time to now read through a very complex document. As very jokingly, we joke with Neha also, you guys, I mean, your one sentence is actually 10 sentences. And we who come from the engineering background, okay, we write things in bullet points, which lawyers hate, because you love complicating things. But I'm saying this with all due respect, just to lighten the mood. It's becoming too hot and too what do you say, heavy kind of a discussion now. So let's lighten it up. So like Neha, when she speaks 7 sentences, herein after, therein under, notwithstanding, keeping this in consonance, read in conjunction with the law section so and so of that law. I mean, by the time less brainy people like us reach the 2nd or 3rd line, we've already lost what we started off from. Okay, and that creates a lot of work for Link Legal, because then we automatically call up Neha for support, like a good doctor that she is, legal doctor. Okay, so here we were told, look at the end user. Please write small sentences, small paragraphs, no notwithstanding, herein after, therein under, and all that. And give minimal cross references. Okay, so if you notice in that act, very few cross references have been given to, say, a Motor Vehicles Act. And wherever you have to give a cross, just repeat that. Now, good drafting also says that you shouldn't repeat, because if you say as per privacy law, or as per this law, as per copyright law, now if the original copyright law changes, I mean, your own document will become contradictory to what is written in the mother act, because I'm a subordinate act, or maybe I have derived my certain clause or a section from the section from another act or from the Aircraft Act. So you just give references, keep it to the minimal, and keep it very simple English, and not a very deep, not big words. Anyway, we don't use Latin and Greek, ipso, ifto, and whatever, inter alia and all that. So if you read through it's a little bit, I won't say a paradigm shift. There's a very nice English word called paradigm shift, but there is a shift. Okay, and Veena ji in Joint Secretary Law in the legal ministry, law ministry, and we really worked hard to, wherever we found long sentences, long paragraphs. We changed it to easy to understand so that even drone startups, because as I say, ignorance of law cannot be condoned. You can't just get away by saying, I was in, it's such a complex legalese that I didn't understand. So we just went ahead and started selling drones without a UI. So you can't get away. Okay. And now with English being simplified, you can't use that excuse also. Okay. Now I'm just conscious of time. It's 4:20, not a great number, 4:20, but I'll try and just do a little nation wants to know rapid fire like our good friend Arnav. Okay. Next question was about privacy. Yes. So we did, now this is another very interesting point. So we did add a paragraph on privacy. You can't do it, thou shalt not, thou shalt not. And it was again struck down by the law ministry because it's another basics of law drafting that you don't repeat a law. And we were told there are anyway very strong privacy laws. Now, if you see a very live case, there was this lady who won, I think, a bronze medal at the Tokyo Olympics, a very famous one. Okay, and when she was getting a medal, that was a public photograph, went all over the country. All of us were so happy tweeting about her. And some people used that in an advertisement the next day. And this lady, she sued those people who used her photograph, a public photograph, in a public channel or a TV channel or a newspaper. Okay, and she took them to court. And I'm told there was some restraint ordered or something. I mean, I'm not a big expert on that particular case, but I was told by the law ministry that in a country where you can't even use publicly available photographs, you can't just photograph Amitabh Bachchan and start selling Bonvita using his photograph. So you don't really need to create yet another paragraph in your drone rules, because the moment you write it, you are creating a separate rule under the drone rules on privacy. So you keep quiet about it and the existing rules apply. Even if you notice in the drone rules later on, we have said that while there are some penalties and fines and whatever, which can be imposed under drone rules, but this doesn't mean that you can be absolved of any other crime that you may commit under the statute, India's laws. So if I take my drone over, say, a girls' hostel, say Lady Shri Ram College, and start doing, I mean, you have road Romeos on the streets. You can also have aerial Romeos, okay, who are flying drones on top of Lady Shri Ram College. One complaint to the police, and those guys will lose some very, very costly drones and also spend some time as the guest of the state, where they'll be treated very nicely. Okay, so there are existing laws which prevent you from, I can't take Neha's or Kashish's photograph just like that without their permission. So in a country which has very strong privacy laws, okay, now you may always complain that, yes, like a true activist, I can always say that it's more, more followed in breach than in following the law or some such thing. It's more by, it's more breach than followed. But okay, that's a separate matter. That's on the execution part. So we were told that you cut out that whole paragraph on privacy because there are already privacy laws, and we don't want to redraft something which is already there because it may not be very comprehensive. There could also be mutual contradictions. There was this question about Make in India and drones, a very, very good question, and it's a target area. And like you see, the PLI scheme, now notice the difference, and these are historical, recorded, known facts. Okay, I'm not going to make any philosophical comments here, only based on actual facts as they've happened. 25th August, we clear somehow girte padte we managed to notify the new drone rules. Okay, and Shaurya Rana just asked a question which I just answered. Yes, we don't have a privacy section drone rules because already there are privacy laws. And as I said, a lady who took all the newspapers to court, or whosoever used, or the brands who used publicly available photographs of winning the Olympic medal. So this is what the law ministry, Veena ji at law ministry told us. Okay, so I was on Make in India. Of course, it's a key target area because see, drones, it is such a sensitive area that right now the unfortunate fact is that they're some 40-50 years behind the West. We are almost 20 years behind our lovely neighbors up north. Okay, this cannot continue. And drones are so ubiquitous. I mean, right now also almost 90% of the drones, these Shadiwala drones or some of the other drones, almost 90 to 95% of drones are just one brand from our friendly neighbor up north. This cannot continue. So if you notice on 9th of February, just this month, about 13 days back, we've come up with the new import rules, which has banned all import of all drones. So this is the biggest support we can give. Now, again, this is a legal question because a lot of people did warn us that this may become a it's a WTO issue, it is not WTO compliant, they'll drag us to court, this and that, there could be retaliatory action. But yet the government has gone and banned, because generally now I know that it's being recorded, we see some of it may go on social media also. But see, I'm just trying to choose my words carefully here. See, a lot of times people also say, by just like some of the other Western countries or some of the other countries, you can always use what you call non-tariff barriers. Custom mein rok do, container rok do. But jiska wo crore rupaye ka consignment lock hoga, automatically the word in the trade industry goes up. Bhai abhi mat lao, ye custom wale rok rahe, JNPT pe rok rahe, Chennai mein rok rahe, whatever. So, just see, despite all these, I mean, so 5 months we have grappled with this issue because we had lots of feedback from industry, from the trade, from different ministries also, many times have divergent views. And after all that, finally the DGFT, which is Directorate General of Foreign Trade, they came up with this import notification, wherein all imports of all completed drones, so CBU, CKD, which is completely knocked down, semi-knocked down, all these drones have been banned. And on the same, in the same notification, all drones of all, all components of drones have been completely freed up. Okay, so this is just another way to promote our domestic drone industry, because at this moment, our component industry will take some time. Components is actually a high volume, low margin industry. So you don't make much money. So unless you have volume, millions and millions of drones being produced, there's no way that somebody can set up a battery factory, a drone battery, because drone batteries are very different from normal batteries. Here, the weight is very important. It has to have a very high energy to weight ratio and a very high energy to volume ratio, because it can't be too big or too heavy, because then it hurts the flying duration of the drone, okay, or the ability of the drone to carry more payload or weight. So the drone battery or drone propellers or the drone motors or the drone airframe, these are very specialized components, and we'll need to get to that level where we start assembling almost lakhs and lakhs of drones, and then maybe somebody may think of setting up the component factory. And once our component volumes also go up, just like we have banned drones, we can always ban any item. We are a sovereign country, and of course, keeping WTO in mind, we can do whatever we want to support our industry. That was on Make in India. There was one last question on contribution by RJNU. See, RJNU is it's a university created. Just hold on for a second. See, RJNU is basically a central government university under the Ministry of Civil Aviation. It was set up as an act of parliament, like most universities under University Grants Commission. This is a separate university under the Aviation Ministry. I happen to be the current Vice Chancellor. It's an additional responsibility given, and I'm sure very soon we'll have a full-fledged Vice Chancellor also. And they are focused on aviation courses. The unique part about Aviation University is too that we have 3 courses running in airport operations or airline and cargo, and also a basic firefighter course. All these courses are industry driven. So it's actually the faculty, the syllabus comes from them. We give the overall governance, and our academic council and executive council, which is full of all the industry people. And these are all approved by the Honorable President of India. So we provide the overall governance, and the infrastructure is world-class infrastructure created at a very high cost. Okay, and we curate these courses based on what the industry wants. So coming to, I think there was this question about how can law be taught. Yes, I mean, we'll be very happy. In fact, with Neha, we've been chatting, and I'm sure very soon Atul, Kashish, and Neha will get together and curate some kind of a course along with the aviation industry. And this could be just a 3-day, 3-month, or a 3-year course. It is so flexible. This university is so flexible, just like US. We can start with anything. And as we always follow a very practical approach in this government, which is to crawl, walk, run. I'll repeat, crawl, walk, run. So we don't want you to run a sprint or a marathon or beat Usain Bolt. First, let's crawl. You can start with a 3-day or a 3-week professional course where you have a very packed, very tightly packed course which covers some of the major areas, okay, of aviation law, because everything in aviation is driven by law. It's one of those last bastions of highly regulated industry, because we are dealing with human lives here. The human lives inside the aircraft, and there are human lives below the aircraft. And these projectiles move, these balloons with people have almost 200, 300, even 400 people sitting inside. It has fuel. and it's moving at almost 800 to 900 kilometers an hour. Our cars typically move at 50, 60 kilometers, and after a drunk party, maybe you can drive above the safe rate at 100 kilometers an hour, okay, on the Gurgaon Expressway. But this animal, this bird flies at 800 kilometers an hour. So with such speed, and it has to land on that narrow strip of land which is barely visible from the cockpit or from your window. If you see it, a tiny runway far away in the darkness, and with those little runway lights, very bright runway lights, and the pilot has to judge his glide path and land it. And every 2 minutes, there's a plane landing in Delhi, Mumbai, and Hyderabad, Bangalore airport. So it's a very, very tough industry, very highly dependent on skill and technology, and this hand-eye and science collaboration. Okay, so that's why the laws have to be very, very strict, because we are dealing with huge amounts of, human lives and very costly assets. And if God forbid there's an accident, it falls in a residential area, God forbid, you can imagine the sort of damage and it can cause, and also the shutdown and the shutdown cost. Maybe it will be the entire airport could be, because of an accident, shut down for 3, 7, 10 days. And you can imagine what kind of a economic and a financial cost and a logistical nightmare that would be if an airport, you shut down an airport for 30 minutes and there's chaos at the airport, because every 2 minutes there's a flight taking off or landing. Okay, you shut down an airport, a Delhi airport for 30 minutes, there'll be chaos. Imagine shutting it down for 3, 5 or 7 days. That's the risk involved, and that's why there's so many laws governing aviation, and it's a very highly regulated sector. So on aviation law at RJNU, we'll be very happy to consider any such course that you guys can come up with, and let's curate that, do that, and young students, graduates, postgraduates, or even professionals can come down and do that 3-day, 3-week, or a 3-month, or even a 3-year course there. Okay, Neha, I think I've stuck to time. It's exactly 4:31 on the clock. So if you have 2, 3 more questions, we can take that, and otherwise we can call it.
So we have a question, from, I forget the name of the student, but I think it was a very good question. Drone control education system to target tribal areas.
हाँ, तो ट्राइबल एरिया, एक तो वो विलेजेस का मैंने आपको बताया स्वामित्व स्कीम में, some of those very high quality sensor drones which are taking these highly sensitive photographs, very sophisticated cameras, and so you see urban kids don't have access to it, and tribal kids, say in the northeast or Jharkhand or Chhattisgarh, they have access to those drones. Okay, those kids come, they watch, and it creates a scientific temper, because once you've done the photograph, even the drone pilots sit down there, chat with the people, and just do a little demo for the village panchayat kids. Sometimes local MLAs and MPs land up because they've never seen a drone. Okay, and these are very sophisticated 5, 6, or 7 lakh worth of drones. Okay, which even the urban kids don't have access to. So for tribal areas, this is the Swamitwa scheme has been a great help. Agri drones also are operating in many tribal areas. Then our security forces, of course, use a lot of drones. So in tribal areas, there is access. And yes, we'll also be opening up drone schools in every state. Okay, so young tribal kids, they are most welcome, and we'll be very happy if they learn that. They can, tribal kids that can help in wildlife poaching, they can assist us, they can keep an eye, search and rescue. If a tribal person from the tribal village gets lost, you can, a lot of people get lost. Sometimes they lose their way, sometimes they get drunk, sometimes they're bitten by a snake or something. And these drones can really expand the reach and get to that person. Also in search and rescue, and also in case of a natural disaster in tribal areas, drones can play a big role. Neha?
Yes, sir.
Rapid fire kar lo, abne to jaldi
jaldi. Last question before we let you go. Just one last.
We can take about 5 questions, but jaldi pooch lo. Jaldi pooch lo, so I can give a rapid answer.
Another question from Arinjay saying, the Krishi drones clearly have helped the agricultural sector immensely. Do you think we could help neighboring countries in using this technology?
Oh, of course, bhai. See, exporters, we always respect exporters. We are encouraging all our youngsters. They are coming from some of the best colleges. They could have taken up a job. Many had job offers from the Tatas and the Birlas and L&Ts and Airbus and Boeing, or even scholarship abroad. Many of these crazy guys have actually let go of those secure, high-paying corporate jobs in Delhi, Mumbai, Gurgaon, Bangalore, etc. And they are setting up the startups, struggling in a garage type of places like a Steve Jobs or a Mark Zuckerberg. And I hope they become as valuable as these guys. Okay, so of course, export market is a big focus. And once they make these agri drones, even as part of the aid packages, I'm sure government will, there's an aid package in Bangladesh or Nepal. I'm sure the government will pick up and export to those countries as part of that package. Neha?
Yes, sir. Okay, so this would be the last question. This comes from Vandana Srivastav, and she's asking, commercial usage of drones would deprive many humans of jobs. How would we address that?
Please don't ask this question. See, first of all, there's a march of technology. As I said, we are 60 or 50 years behind US and 20 years behind China. We can decide to go 40 years behind China. And the drones, if they have to come, just like your lab, can you live without a phone now? I could have said that if you didn't have a phone, just to send a message to Atulji to send that file, I would have used an office boy. Yeah. Today, I just pick up the phone and speak to Atulji. We can even do this VC. If we didn't have this VC facility, we would have had to meet physically. I would have loved to come to Faculty of Law in Delhi University. Okay, but it would have meant there's so many jobs, so many cars, so many people getting together. I'm sure then Atulji would have arranged some samosa today. He's escaped the cost of treating us to samosa and cake pastry. Okay, so cake pastry walo ke job chalega. Now should we stop the video conferencing? So see, I know it's a rhetorical question with all due respect to Vandana ji, and don't ask these questions. Yeah. See, technology is technology. Respect technology, because we didn't do that. We are trying to cover up our mistakes of the past. As a government officer, I'm openly saying we are 50 years behind the West. We are 20 years behind our lovely neighbor up north. The next war will be fought on drones. You may have a great fighter jet or great missiles, but I mean, once a fighter jet takes off and some 10,000 swarm drones come from the other side, you can have the best of the fighter jets. It's like a lion fighting against 10,000 swarm bees, or a swarm of bees. It's not the bees who will get killed. It's the lion which will do kathakali when a beehive is broken on top of the lion. He might be the king of the jungle, a senior Simba, but he'll dance kathakali when you send the 5,000 honeybees or wasps behind that lion. So the future wars, I didn't want to get into this war mongering and this war business, and that. Please realize there's a very destructive side of drones, and one of the reasons why we are also supporting a drone industry so crazily right up to the Prime Minister's level, because we want them to innovate, and some of the best suppliers to our military agencies, and they're working with many of the companies are the same guys who are also working on agri drones and survey drones and this thing. Okay, so just to close the story, it's the same thing as saying railway reservation ko online kyun kiya, computer kyun laye, mobile phone kyun laye, internet kyun laye, because ye nahi late sab jagah manual use hota. So no, it will not. First of all, technology has to be respected, and we have to be at the cutting edge with the rest of the world, because जहां से भी टेक्नोलॉजी आनी वो तो आएगी, अगर हम नहीं बनाएंगे तो इंपोर्ट होगी, और अगर कहीं जॉब्स जाने तो जाने नहीं तो साथ में खुलते भी हैं. Okay, for every new technology that comes in, if the huge IT industries come in, where was Satyam and not Satyam, but Infosys and Wipro 30, 40 or 50 years back. But when they came, today they are the largest job creators. Thousands and thousands of jobs are created per annum by Infosys and Wipro. And then the support jobs, because the support jobs are 5x. Somebody feeds those canteens and those the Innova and the Qualis, which bring people to the Infosys office and takes them back, or TCS. Okay, so let's not get into this technology versus jobs. There'll be, instead of just being a farmer's son, you'll actually be a drone pilot. Okay, as a farmer's son, do you want to be a drone pilot, or just be like your father and just do spray and pray and get your lungs spoiled? Neha, over to you.
Yes, sir. Thank you. Thank you so much. This has been extremely, extremely enriching. The keywords has been definitely national interest, and we are moving forward with that. And thank you for, taking this lead role in making drones a possibility, a real possibility for our nation. Like you said, we don't want to remain 40 years behind. We want to go ahead as much as we can, map it. And with your guidance, I'm sure we'll be able to do it. Thank you so much, sir.
Thank you. Thank you so much, Ambar, for taking.
Thank you, sir.
Been a pleasure. अब एक बार physically भी कभी करते हैं दिल्ली यूनिवर्सिटी पे, बहुत हो गया ये VC. So boring.
We will arrange.
452 people on the call. I can't see other than 4 people. I mean, it's so painful talking to a screen.
वो Miss Chawla से बात करके वो करते हैं. That will organize. Don't worry. Yeah. Thank you so much.
Thank you, sir. So we move on. Before we move on to the next speaker, I have a small announcement to make for the students. I would like to remind all the students to kindly make sure that they attend all the sessions in order to become eligible for the certificate and the internship program. At the end of both the days, we will be posting a link to a feedback form to enable students to make their attendance. Also, we'll be making a compendium of all the questions that have been asked during this session and also the next session. And we will be circulating it to all the registered members. As a question answer format, so that we are able to address all the questions that have been raised, because we respect every big and small question that has been raised, and there are many questions. I'm very happy to see that you guys are attending and enjoying and actively participating in the event. With that, we go on to the next speaker. Our next speaker is Ms. Vanda Aggarwal, who is a career civil servant and economist. She joined the prestigious Indian Economic Service in 1986 after her studies at the University of London and Delhi School of Economics. Presently, she is nearing completion of her PhD thesis from the University of Delhi on a study of investment and regulatory aspects of deep sea mining in the Indian Ocean. She is currently serving as a chairperson of the Interdisciplinary Committee on Developing Avenues for Ship Acquisition, Financing, Leasing from the IFSC in India, set up by the IFSC Authority of India. She also serves on the different high-level bodies such as the Council for Scientific and Industrial Research, National Aerospace Laboratories, High-Level Research Council for Development of Aerospace Sciences and Technology, Infrastructure Facilities, Expertise, and on the Board of Directors of Central Public Corporates and Councils. She last served as a senior economic advisor in the Ministry of Civil Aviation and was divisional head for over 4 years for economic policy and economic regulation, air cargo and logistics, Krishi Udan scheme, GST and taxation matters, aviation financing, including Rupee Raftar, aircraft leasing and financing, development of fixed-wing regional transport aircraft and light utility helicopter, and an ecosystem for manufacturing aircraft in India. Maintenance, repair and overhaul, skill development, competition issues, convergence between defense, aerospace, civil aviation, and MRO manufacturing, and research. Apart from a rich experience in advising various ministries and government bodies, she is also credited with the creation of the Indian Aircraft Leasing and Financing Platform at Gujarat International Finance Tech City, which is the GIFT IFSC, which is based on the Project Rupee Raftar, which was formulated under her leadership. Ms. Aggarwal has contributed immensely to the field and has been a role model and mentor for so many like me along her career journey. It is my pleasure and honor to invite you to speak in this session. The floor is yours, ma'am.
Thank you so much, Neha. Your words are very kind, and I'm not sure I can do justice to mentoring, but I do like to be with students or those who have a lot of creative energy or the will to do R&D or any form of research. I don't think that age is ever a bar, or I think the mind is a wonderful organ, and we should use it till our dying day. And so I hope that all the students here will find some good takeaways from not just this course, which is very well crafted, I think, by you and Link Legal. I would like to thank the organizers, all of them, and for the meticulous attention to reaching out to panelists. Let me first get into the very wide topic that you all have given me, which is, the entire aviation sector and its economic underpinnings. I don't think we should get into that in too much of detail, but I will try to focus on some key areas and try to provide to the students from a law perspective as well, apart from the economics of it all, some useful insights which they can then bite into. Let me start by just sharing some shocking numbers, which is on the aviation penetration of India. So I joined the ministry 4.5 years ago, or rather I served in the ministry for 4 years, and that was my first experience with civil aviation. And I just happily asked the question, what is the aviation penetration of India? And the year was 2016-17 or 17-18. And I got a reply that we don't know. So I set about trying to find out as to what India is all about. And I discovered that as compared to even other developing country markets like Brazil or Turkey or Indonesia or China, what to speak of the US and Norway, our aviation penetration was quite low. So if we look at domestic air passengers as a percentage of total population, we were at about 4.7% in 2013-14, but by the time we came to 2018-19, it had increased to 10.2%. Note the hefty increase, because this was actually a period of very rapid and unprecedented aviation growth. Air travel penetration rate, and I take the domestic one. I'm just giving, just 4 numbers I'm going to give to the students, or 4 markers I'm going to give to the students so that they can, in future, develop them as the 4 pillars or the foundation from which they must gauge the growth of the aviation sector. So air travel penetration rate, which is usually the annual domestic carriers seats per capita. So it's how much installed capacity in terms of seats you have, which can be offered to passengers on an annual basis. It was only 7.2% in 2013. And by the time we reached 2018, it was 12.4%. Now, if you look at Norway, etc., they were at a huge 47%, etc. So, that's the kind of gap that we had on the air travel penetration rate. International was much lower. This is the domestic one. If we look at contribution to GDP, which is, again, another very important marker, India contributed direct aviation GDP was 0.5%. And if you add the direct, the indirect, and the catalytic GDP impact on GDP, then it was 1.1%. Or rather, if we want to put numbers to it, it's about $32 billion US. And the total global aviation GDP that we have is about 3 trillion. Okay, so that's the kind of penetration that we had in terms of contribution to aviation GDP to total GDP. India held, but if you look at jobs, I heard the question on jobs as well. India held 4%. Now you remember, GDP was 0.5%, but India held 4% of global direct aviation jobs. And another number, which is very telling, is the global jobs that were generated, 12% of them were in India after you add the catalytic impact of the tourism sector, with which aviation is intrinsically linked. So this is the kind of background from which you have to look at India's aviation. Now let's see. When we studied further, we found that Indian aviation was both resilient and promising. What do I mean by that? What were the markers that we were beginning to look at? You look at passenger traffic, you look at regional connectivity, because it can't be overall numbers, there could be regional variations. Air cargo and logistics. Do we have global hubs in India? Do we provide the milk runs for cargo, the east-west runs that we normally see from Asia to Europe or the US, which is the east-west milk runs, the daily movement of cargo? Did India contribute to it? Hardly at all. So it was basically India's cargo, which was moving out, or India was importing cargo. Of course, perishables and pharma, these are 2 very important exports, and we were doing pretty well in that. And we improved it further through specific measures as well. Airport capacity, did we have it? Airport quality, we have been operationalizing non-operational airports. We have been monetizing the tier 2 and tier 3 airports. These are all bids to improve the overall ecosystem. We have scheduled and non-scheduled aircraft fleet. I'm sure the numbers can come to you in the course of the discussions. But dedicated freighters, we didn't have them. Air India had 4 dedicated air freighters, but they were not in use because they were being used for other purposes. And or they needed maintenance. And it is in 2018, after we put in a very important surge and a new air cargo policy for the first time as a standalone policy, that we started seeing the air freighters, the dedicated freighters being developed by being bought or taken on lease and being run by our scheduled operators. SpiceJet was the first one to go with 5 freighters. And, during COVID, I'll talk about that. They were literally the lifeline in providing the essential goods movements, the medicines movements, the vaccine movements, and so on and so forth. And thank God we moved for a very good national air cargo policy, which enabled our airlines to lease dedicated freighters. Then air navigation and air traffic management. Ambar did speak a little bit about the traffic management in the context of drones. Well, you do it in the context of planes also. There's a huge safety and security angle to it, and that is something that guides the whole thing. Civil MRO in India, we did have the Air India's wholly owned subsidiary, which was providing about 85% of the entire MRO that was sourced domestically by the Indian Airlines. And the other private players, Airworks, etc., were providing the balance 15%. But in overall terms, if you look at it, India was sourcing practically 90% of its total MRO needs from abroad. So it was mainly line maintenance, which is a very quick check, etc., which is done here, was being done in India. And very swiftly we moved. I was handling the MRO portfolio. We came out with MRO policy, etc., tried to see how we could bring tax breaks. These were very important tax breaks, which got announced by in the union budget for 2019-20 and 2020-21. And I hope that going forward, we will see a huge amount of difference. We also worked, I was chairing the group, and it was conceptualized by us, of convergence of MRO between civil and defense MRO. So that is something that we took up again in a very strong way. About 20% of the defense fleet is non-weaponized fleet. You have the transport planes and so on. So it was easy to try to see how we could have more economies of scale so that the defense MRO could be done at our civil commercial MRO stations, organizations as well. A lot is there about inputs into providing aviation services and the fuel, ATF, and all the taxes associated, not just with ATF, but also the newly introduced GST. That was, again, my dossier. I had just joined in May 2017, and 1st of July, the new GST Act had come in. And from aviation, we had to take up a huge number of tax changes, which inadvertently were causing an excessive taxation on different aspects of the aviation sector. So we needed to take that up at breakneck speed. And thankfully, we found a very, very good audience in the Ministry of Finance and the GST Council. Ground handling and allied aviation services. This is another very important component. Why am I talking about all these components? It's simply because in the entire value chain, you must be able to ensure that every rung, every link is strong, because the adage that any chain is only as strong as its weakest link. So if ground handling or any other MRO is weak, or manufacturing is weak from the very beginning, or the sourcing of inputs or components is weak, then obviously the services delivery will have the added cost, because the अर्जुन को जो मच्छी की आंख नजर आई थी जिसमें तीर मारा था, and he was successful because he focused on the arc, is basically the transaction cost to the consumer, or rather freight rate in the case of cargo and passenger tickets in the case of passenger services. Everything else is, part of the links that go back. And so we have to, in determining the health of the aviation sector, always be very sure that we are ensuring that this cost plus regime is addressed, and the final price or the freight or the cost to the airline which is providing the delivery of service, whether the air transport service, whether it's passenger or freight, that is affordable and it is competitive. Both factors have to be taken into account. That's why if you look at in India, we have basically two models which are going. One is the scheduled operations and the non-scheduled operations, which are operating in a competitive pricing regime, and it's a competitively determined market price. Whereas if you look at the Udan scheme, and also subsequently for cargo, the Krishi Udan scheme, for instance, that is based on affordability. So it has a notion of how to remove the impediments, the cost impediments in providing services to disadvantaged areas or to people who would otherwise not use air transport services. Drones, it was another ecosystem which needed to be developed, and Ambar has spoken enough on it, so let me not say anything. I will just add to one comment. Ambar was a little diffident in answering as to why on the issue of the WTO compliance of the ban on drones. I've done WTO negotiations for Government of India, including at the Permanent Mission of India to the WTO at Geneva. A total period of 12 years of my life I've spent on it. So the justification is to be found in security. It's also to be found in public health and public safety, because we find that where drones are concerned, if you're importing a full one, it's very difficult to examine at the border itself and to be completely sanguine that the drone does not have a danger. It does not pose a threat or a danger to the public at large or the user. So it's government is within its right to use these exceptions for putting restrictions until it can put in place a system which is has the requisite level of protection. I'm not saying you can ever have a completely foolproof system, but where the level of protection to the public at large is sufficient for it to remove the ban. Then where aviation sector, coming back to it more generally, is concerned, you have consumer satisfaction and grievances, redressal performance. We took care of service level standards. Quality was such an important thing. We brought in quality metrics, not just for airports, for cargo, for different levels of services delivery. So these service level standards were set. We went for single window and automated approvals, the EGCA, ESAHAJ, et cetera, And one of the areas which has, from my very intervention, first statement, R&D and modern technology, artificial intelligence, digitalization, these are all what I would say necessary coins in our pocket. in our aviation pocket. So this is something that we don't have a choice in the matter. Although I speak of R&D, it does not, most of the times we think it's something to be done in a laboratory, but I think in law schools as well, a lot of research and development can go into the laws that we draft, or how they are to be implemented, and what's the best way to adapt to the processes. Because after all, you have the physical, the goods or the equipment, the manufacturing side, then you have the financial overlayer, and then you have the soft skills, which include not just technology or the software, but also the legal systems or the services delivery. So I think all the three layers have to work in a very creative way. Many of the times, and this is not a criticism, I've been a drafter of international WTO law on behalf of Government of India. I used to find that India would shy away from accepting to draft the negotiating documents or any piece of regulation. Whereas I think that how it develops the legal mind is phenomenal, because you have to learn what are the commercial underpinnings of that particular law. You have to learn about issues like privacy, about all the other attendant factors or conditionalities that have to be kept in mind, the state versus the central positions, how it matches with the constitution, how it matches, correlates with other laws in the country, because it's not an absolute law that you are putting in place or a regulation. And also finally, on how easy will it be to implement, and the implementation is easy read, easy for the courts to handle as well, so that we don't have a very strong need for litigation. So, the words that are put in should be, you have to balance the interests. So there is always a nuance or a balance of interests that guides us when we are drafting law or regulation, but there should not be ambiguity in it, or it should be easy to provide basis for the judiciary to interpret it, seeing the circumstances of that particular consumer. Is it a small scale consumer? Is it a large scale consumer? Is it who is it? So I don't want to tell you, I'm sure your teachers and your professors are already telling you all this, but I'm just saying it from the point of, so I used to always tell them, let me draft it. And, I could therefore go from a position of strength, simply because India is a whole mishran of a developed world and a developing world. As people keep saying that you have a poor India and you have a rich India. So you have everybody. You need to take care of the interests of the large corporate. You have to take care of the interests of the small and the informal sector as well. When we're drafting something or providing rules, you have to take care of our small farmers. You have to take care of our large plantation crops as well. So, you know best how to put the issue down so that the interests are met. And very surprisingly, I used to find that most of the developing countries used to tell me, we are very happy that you are drafting it, because we know large and small, island economies, small economies, bigger ones, South Africa, Brazil, they would all, sort of say, no, it's good if you're drafting it. You will put a balanced perspective to the draft. And negotiation used to be very easy on it thereafter. So Neha spoke about the value proposition for aircraft financing and leasing. That was, again, an example of how we first, so I wanted to bring the whole issue of large mobile equipment or assets, which are amenable to leasing, to India. But in the law, because we were a little unsure as to how it would go, and you always do building blocks. So we first went with the aircraft leasing ecosystem, and subsequently I have chaired the committee for ship acquisition, leasing, and financing as well, so that out of the IFSC Gift City, the ecosystem is one which is compelling for all large mobile assets, which are bankable and which are amenable to leasing. So that could be your metros, could be the next railways, the engines, the bogies, etc., satellites, you name it. I mean, any large asset could be taken up in the Gift City. That's the intention. And the 7th January 2022 notification that Finance Ministry has kindly come out with after our recommendations were made in November last year is aimed at that. So the IFSC authority now has the ability to declare which are the equipment and the associated simulators, etc., accessories, which are to be called a financial product, so that they come within the ambit of the IFSC. So that's something. I just want to, before I go further on, I forgot I needed to touch a little bit the importance of human resources. I cannot tell you how important that is. Indians, I find, after having lived abroad and worked abroad for such a long period, we love to do kunji reading. Our entire approach is driven with shortcuts. Ek koi kunji bata do, usse pad lenge, because we just need to read what is sufficient. Even in the 12th standard, when I was in London, per subject, I used to be given a reading list of at least 100. So for maths, 100, physics, 100, XYZ, 100, minimum. And we had to know them because there were no choices. You didn't get too many choices in answering questions. You had multiple choice questions. You had short answer questions in separate question papers. You had essay types, and then you had your research questions. So every subject had that. And that's how you hone the mind to look at any complex issue and then find solutions. I like to think that I think on my feet, and the varied subjects that I have dealt in the government of India in my entire career. I can't claim to be an expert on aviation, but I spent 4 years and I tried to come out with at least 5 new initiatives. I'll tell you about the others. So one was aircraft leasing and financing. The second was the MRO policy. The third was the air cargo policy. Then on vaccine, I'll talk about the crisis management and the heading of the emergency supplies and vaccine movement, the crisis management we did. I also worked on airport financing, which is something different. So, you know, I would urge all of you, build your foundation well and know much more than what anybody else does and put it to good use. You know, the devil lies in the detail. And as lawyers, you would already be very familiar with. So the aviation education and skill building that we adopted in Ministry of Civil Aviation, it was precisely to lay a strong foundation with an inclusive approach. So you have the National Civil Aviation Policy 2016, which sets out a comprehensive roadmap for providing skills needed by India's surging aviation sector. And you know, this is through PSU managed training institutes, which already have a strong skilling ethos, like Air India and its Airports Authority of India and its bodies, etc. Pavan Hans Limited is another example. Then Aviation University, Ambar has spoken about, but there are also other state-of-the-art aviation-related educational institutes, and I'm happy to learn that you all are bringing in specific courses as well on aviation. Then you have your flying training organizations, which take care of not just the commercial pilot licenses, the airline transport pilot licenses. You have the aviation maintenance engineer, AME institutes, which take care of the AME licenses and so on. Then you also have for security, the BCAS accredited aviation security training institutes. You have the air traffic control officers, the CNS engineers, the airport operators, the fire personnel training. And we also have skill development centers. And at the other end, we are trying to ensure that India's skilling footprint is much higher than what it was earlier. Otherwise, you would have heard about Indians going abroad for skilling and so on. The curriculum has been standardized, the QP have been worked out, qualification packs and national occupational standards for bulk of the levels 1 to 10 for different types of skills that are required. But much more needs to be done. For instance, we don't have sufficient participation of industry in skilling, although they are the ones that are most benefited by it. So industry does need to go and do more. Academia needs to do much more in determining the qualification packs and the skilling curriculums. The engagement has to be much more. Otherwise, you're just leaving it to very many. I'll give you a very cute example. We were doing a quality check on a draft curriculum for a cargo course, cargo security handling course. And when we asked obviously we asked different airlines also to send their personnel. We were sent somebody who was doing the ticket reservations. Now, how would a person who's doing ticket reservations be able to provide quality inputs in drafting a curriculum? So obviously, I blew my top and we finally had to reschedule and we got the right person. But we need to recognize our sense of responsibility to developing these at levels which are high tech. India has played around at the lower levels for far too long, and I think it's time for us to provide our space in the sun. On the ecosystem, I have already spoken about, I don't know whether you need the numbers, how many MROs there are, how many scheduled operators there are, how many airports are operational and all that. I think that is something that can be taken up in question answers in case you do wish to. How much time is left? Because I would like question answers as well.
Ma'am, we have questions. We can do another 10 to 12 minutes for this session. So if you want to take questions, we can take questions also.
Okay, so just first, let me very quickly run through some of the drivers and some of the other things on the aircraft leasing system, which is as you know, one of my favorite subjects at the moment. Let me take you down another track, actually. How do you measure? So I told you that we had a very low penetration and we were starting from a very low foundation as if you look at when the sector was to take off. How do you judge that in the years of growth, unprecedented growth that we saw from 2014-15 onwards, double-digit growth, 20% plus growth in PAX traffic. Cargo went into double-digit growth as well, which was unprecedented again. How do you measure that, yes, you're on the right track? So it's, fortunately or unfortunately, this crisis management of COVID and the response of COVID is a great measure. So the aviation sector, which was actually the worst hurt because there was a complete shutdown. There were no packs which were allowed to move. But cargo needed to move because I coined the phrase, let's run air trucks. because that's the safest way during the first lockdown to provide all essential services. I'm sure all of you would have found that you were not lacking for essentials, whether it's toothpaste, toothbrush, your soap, your milk, your vegetables, the atta, dal, chawal, gehu, aloo, pyaj, everything was being delivered. How was it being done? There was a huge coordination. So air took off first with air cargo because all these were perishables, milk, etc. We took concentrated milk, but we worked with post office and used the post office vans to deliver milk because they were easily identified, and at the check nakas and all these could be allowed to go through. So there was a huge amount of response to the COVID-19 pandemic. So where aviation played such a pivotal role in unhindered and timely air transportation, after ensuring that all the COVID-19 safety protocols are followed. So this is so important. Keeping safety in view, everything was done. People in need and essential service providers, they were being moved through Vande Bharat mission, air bubbles. There was calibrated domestic operations, opening of the sector in a calibrated manner. Then on cargo, as I said, temperature controlled, daily transport of vaccines, both domestic and international. India is a case study. There's a BBC documentary also on how, without spending on cold chain infrastructure, which everybody was telling me, develop karo, develop karo. I said, nahi chahiye, nahi chahiye. We can't handle -70 at our nurses in some Leh Ladakh or in Andaman Nicobar Island. How will we open them? Kaun dega? Within half a second, 1 second, you have to administer the injection. So, all that was very difficult. So we worked with easy systems, but not a single mishap. Have you heard of anything? Shortage of vaccine or any mishap? No, simply because we could manage the temperature control daily movement very well. Then we did facilitated air cargo. So initially, PPE kits chahiye, gloves chahiye, medicines chahiye, the active ingredient APIs chahiye hote hain to make the medicines, because it's not just the vaccine that's needed. You needed so many other medicines, not just for the vaccine COVID-related disease, but also for heart patients, for diabetic patients, and so on and so forth. So all that had to continue. So we did Lifeline Udan, we did Krishi Udan, we did materials for industry, because everything has to move. All that by air, we did very well. And kudos to the aviation personnel. Apni jaan ko jokhim mein dal ke, we used to get so many volunteers saying, I'm ready for it. When India did the first evacuation out of Wuhan, Air India just jumped, and the senior most commanders are telling us, we want to pilot that plane, etc. So it was fabulous. We did so much of evacuation, not just of Indians, but of non-Indians as well, from the worst hit places, and it was done very successfully. Then we we prioritized the ferrying of critical medical equipment. Aapko last year ka oxygen containers, concentrators, generators, ventilators, and all that. So we were at the front end doing that. Then we needed to provide air navigation, airport facilitation, customs and regulatory authorities ke saath milkar sab baith ke karte the. So, all this was done as a part of the response. It's not been documented, but this is a story which India succeeded. Our vaccine Maitri succeeded, despite all the, local brouhaha which we keep having with the naysayers and all that. We did very important policy interventions for rapid clearances and for logistics facilitation at all airports. We waived cargo terminal charges by I-class or the public sector. Obviously, we can't, the freebie regime cannot work at all times. So we were very measured in that. All the safety protocols I've already mentioned, cargo flights, etc. And then, of course, the vaccine drive. So whichever way you look at it, this fabulous response in crisis when everybody is at sea shows how well the aviation sector has grown and it has been buttressed over the years of dedicated policy interventions, lawmaking, and so on. Now, if I were to just turn very quickly to Rupee Raftar, we had realized that, so where did we get this thought? The leasing cost or the aircraft cost was such a high element of the passenger tickets or the freight ticket that when I started looking at it as to what it was on a comparative basis with other countries, I found that India's lease loads or the lease factor was much higher even in the case of our best airlines as compared to the world's best airlines. And so we needed to bring down the costs, and we needed to put in a system which gave us Atmanirbharta as well when we looked at it. So it was an opportunity whose time had come, and the development since then shows that, frankly, the leasing future is here in IFSC Gift City, and we can all work in the happy notion that we can make India the next aviation hub, and to give it, it's already one of the top 3 aviation markets after US and China. And there was a need for in-house lessors as well. So we began to work on it. We already had a very large aircraft order book. The growth of air traffic was already there. We had the 3rd largest aircraft order book after China and US. And we were all set to grow. The revenue potential was enormous. And the commercial jet backlog we had estimated in the committee was about US dollars 19.32 billion. So if you want to see, that is the kind of numbers we could use to convince the government that it can make its investment in setting up an aviation leasing hub at IFSC Gift City. So the value proposition, as I called it, we put it in order. We did minimalist but changes in taxes. Everybody loved to tell us from the very first go, make all taxes zero. Singapore mein ye zero hai, Dubai mein ye zero hai, Hong Kong mein ye zero hai. So we said you can't do forum shopping, but let's work out what is the overall competitiveness of, including tax competitiveness overall, of the IFSC Gift Center. And we ensured that the direct tax changes and the indirect tax changes were sufficient to give India at least a 2 to 3% advantage over the best, which was Ireland. Okay, the most competitive nation, which was Ireland, and the others as well. So we put in the system, and I'm very happy to say that, the report was submitted on 10th of January 2019. On 1st of February 2019, the Honorable Finance Minister already announced that India will accept and go for recommendations, study the recommendations and give effect to it. A high-level committee was set up under the Civil Aviation Secretary and the Secretary Finance, the DEA Secretary. And the changes were given effect to. So within a period of 6 months to 8 months, the essential changes had already been made. And within a year of this initiative, we already had the first aircraft come in from Gift City on lease basis in July 2021. So you can see how fast the whole thing moved, despite the COVID, despite everything else. So there are some things that I wanted to talk about, such as the importance of the Cape Town Convention and what all we need to do. But on the way forward, I will just give you that even as far as leasing is concerned, what are the actions which are currently going on? One, that the Cape Town Convention and the protocol provisions are to be enacted in domestic law shortly. Of course, we've created the platform for aircraft leasing and financing at IFSC. So now what else needs to be done? we working on an online national registry of aircraft, engines, and any other lease parts. This will be the first in the world to be set up. And we are in the process of, setting up a online financing platform for the smaller aircraft as well. What do I mean by that? Banks usually don't look at taking assets on mortgage or having a lien on them if they are 5 crore ka hai, 10 crore ka hai. Till you talk to them about 50 crores and more, they chaff at providing financing. So we have come out with a innovative financing platform so that the small jets, the helicopters, etc., which are valued at say up to 10 crores per aircraft, those can be brought into India. So these are some of the important steps going forward. I would hold my horses at this point of time and look forward to any questions if there is time. Otherwise, next time.
Thank you so much. This has been extremely informative. Like I said, your experience is extremely vast, and you have, like you said, in your tenure, 5 new things were initiated, which have seen the light of the day and which have made immense progress. And about the questions, I think we're running absolutely low on time, but I think if possible, we'll try to formulate answers and share it with you to have your inputs on that.
Thank you so much.
Thank you so much, ma'am. This has been incredible. Thank you so much.
Thank you.
Thank you. So
over to you, Kashish.
Yeah. So now let me welcome Mr. Sharma. Mr. Sharma is the managing partner of Link Legal. He has more than 40 years of experience in the field of law. He has done his bachelor's in economics and law from the University of Delhi. He was admitted to the bar in 1978, and he advises clients across various practice areas, with special focus being on aviation and infrastructure sectors. And he represents clients in these sectors on all aspects of setting up of airlines, including acquisition of aircraft financing, leasing of spaces at airports, securing permission from civil aviation authorities for airline operations, and related approvals from the government agencies, engineering and commercial contracts as well. Mr. Sharma specializes in aviation and infrastructure sectors and represents diverse clients in these sectors on all aspects of their commercial and day-to-day operations, and is highly recommended by various global legal directories in aviation, dispute resolution, projects and energy, antitrust and competition. I would like to add that he has been accoladed as the leading individual for aviation and aerospace and defense dispute resolution litigation by Legal 500. He is featured as one of the elite members of India's top 100 lawyers, and he regularly features as the elite A-list lawyers in various directories. Over to you, sir.
Thank you, Kashish. Well, I have a difficult task at hand, obviously, because you have seen a perspective so far on the regulatory side. And Ms. Aggarwal has been very erudite and clear in terms of the economic issues which she has handled at the government and what typical issues arise in the aviation sector. But when you come to the legal side of it, I believe that it is very important, especially for students, because I was doing an analysis of the attendee list yesterday, and I came to know that 75% of the attendees are students. So there I would take the liberty, and therefore I tweaked my presentation a little bit, I would like to take the liberty of going back to the drawing board. And why I say so is that we all know as students of law, I mean, I'm still a student of law, having practiced for so many years, I still can't claim to be a master in any subject, because the whole legal regime evolves with the society. And any law which is promulgated or is implemented is essentially to service the needs of the society, and the society and the law cannot exist in a vacuum. So therefore, if we go back to the drawing board, and what is very significantly important is to understand the context in which the aviation laws have evolved. So what I'm proposing to do is, because to give you a background right from the beginning, and we are obviously talking in the context of India, but then aviation is something which has such a huge amount of international interface that it is impossible to understand the regime in India and how it evolved over the years without really understanding the international side of it. And therefore, I will take you through the entire evolutionary process, because I believe that it is so very important. That's why I always say the parliamentary debates on a law are such a critical source of really understanding the requirement which is supposed to be addressed by that particular law. So moving ahead, I'll give you the lay of the presentation. So what we'll be dealing with is these bullet points. The first is, of course, and I'm doing this in the sequence of how it happened. And therefore, it is, in a sense, pretty historical. But at the same time, it will give you a sense on what is it that necessitated every step in the aviation field. Now, I'll deal with the evolution of the Aircraft Act and corresponding aircraft rules in India. And now, mind you, this was as early as 1919. And everybody who has dealt with aviation is always familiar with the Chicago Convention, which talked of the freedom of air rights from an international perspective. But then the 1919 Aircraft Act came even before the Chicago Convention. So in a sequence, I would be dealing with the evolution of the Aircraft Act, the Chicago Convention, then I'll move to the constitutional provisions, because then we have an independent India, and then you have a constitution which would deal with the subjects relating to aviation. What are the typical provisions in the constitution, which are the Grundnorm and source of law. Then I'll deal with the nationalization of the Indian aviation industry, which was pre-existing. Now we have come full circle. Tata's had an airline. They come back as a private airline after acquiring Air India. So we had a private airline, then nationalized, and now back to private sector. So that is what I'll deal with. Liberalization leading to emergence of reforms, then privatization, how it ceased to be a domain of the government only, and how the private sector came in. The basic Indian legal framework, the regulatory bodies, their roles and functions, and key industry data. So that's what I propose to deal with, and we can move forward to the first part. Now, if you look, as I said, the history of aviation in India is not new. Notwithstanding that the aviation did not start in India, the legal part of aviation regulation can be traced back to the year 1911. And when, for the first time, there was an instance of carriage of air mails being done through commercial air transport. Then in 1911, a gentleman called Henry Piquet took off in a Humber biplane from the industrial and agricultural ground in Allahabad to Naini with airmail, consisting of letters and postcards. The first airmail flight in the world was inaugurated in India. And then the Indian Airship Act 1911, also known as the 1911 Aircraft Act, came into existence. This obviously applied to the whole of British India, because at that time, British India was much larger than what it is today. And the airship was defined to mean a machine which is fitted with the mechanical or other means of propulsion, designed to fly or float in the air without connection with the earth. So that is section 2.1. So for the first time, we came across a definition of airship. Moving forward, now section 3, 4, and 5 of the 1911 Act defined powers and functions of the Governor General and Council, including those for making rules for licensing, manufacture, possession, use, sale, import, and export of airships. And of course, the word then was airships, it was not aircraft. Well, broadly speaking, even the current legislation deals with all these activities of licensing, manufacture, possession, etc. In 1919, what came was the Paris Convention, which was the first convention of its kind to which British India was a signatory. And this convention envisaged that every state should have absolute sovereignty over airspace above its territory. So like the laws of seas, we walled an international arrangement for who will have sovereignty over the airspace. Nationality of an aircraft should be that of the nation where it is registered. It's not where it is operating, but where it is owned and registered. That holds good even today. Rules pertaining to operation of aircraft, certification, and competence of pilots should be universalized. So they wanted to universalize the rules pertaining to operations, certification, and competence and testing of pilots. The Indian Aircraft Rules 1920 were framed under the 1911 Act. And then since that enactment, rapid development took place in the aviation sector. And then for the first time, as a result of the Paris Convention, the government formed the first Indian Board for Civil Aviation. And then this Civil Aviation Board made various recommendations, including proposals for establishing landing grounds which you call as airports. In the Act, the word used is aerodromes. In the rules, in the current Act and rules, surveys of the main trunk routes and appointment of a full-fledged director for civil aviation. Moving forward, we had the Aero Club of India. It came in 1927, and JID Tata became the first person to be awarded a pilot license on behalf of the club in February 29. And as a result of the recommendations by the board, Lieutenant Colonel F.C. Shalmardine was appointed the Director of Civil Aviation in 1931. 4 civil aerodromes were constructed in various districts of Calcutta, Allahabad, Karachi, and Bombay. Under the aegis of the DGCA, the Director General of Civil Aviation, which continues to be called the DGCA till date. And of course, in 1930, now there is always this dichotomy between the airspace control by the military requirements and the civil requirements. That's why there is a distinct line between military aviation and the civil aviation. And we are mostly conversant with the laws relating to civil aviation, because those are something which are in the public domain, apart from the operating issues. But how they are going to be managed is within the domain not of the public bodies, but certain departments of the government, which is in the realm of Defense Ministry. Then Indian Air Force was established in 1932, and Tata Airlines came into existence for mail services. Moving forward, as I said, the Paris Convention was to establish regulations of universal application and encourage peaceful exchange with nations, between nations by means of aerial navigation. And then, of course, the 1920 rules, as I said, came into existence. Because there were some shortcomings in the Act, it was not possible to just carry out the amendments. And then came the 1934 Act to enlarge the rule-making powers of the then Governor General. And this is the Act which till date governs the field with regard to operations, maintenance, etc., of aircraft, and consequently, in relation to the aircraft, the aircraft operating ecosystem as well as infrastructure. Then came the Indian National Airways, the second airline to commence after Tata's in 1933, which was much prior to the enactment of the 1934 Act, which is now holding the field. And then, of course, the 1937 rules were made under this Act. After this came the much talked about and very well known Chicago Convention, where 52 states signed a convention in Chicago, which is called the Final Act of International Civil Aviation Conference. And this ICAO was formed under the convention, which played a pivotal role in development. So this is the body which ultimately lays down all the standards of how the intra-country obligations will be determined, and what are the compliances that at a global level, the civil aviation or the aviation industry per se has to comply with. And of course, as I said, one of the functions was to adopt international standards set out in the convention. These standards are constantly reviewed by ICAO and amended from time to time, to keep pace with advancement in technology and new systems. But these standards broadly relate to the communication system, airports. Obviously, you have something, if you're coming from London to Delhi, you should precisely have a clear-cut guidelines as to how, when you land at Delhi airport, what is it that you will be supposed to do? There has to be a uniformity with regard to the protocol that will be followed. For example, there is a notification which is issued and is called a NOTAM, which is a notice to airmen. So once you are opening an airport, creating a new runway, changing the alignment of the runway, you need to notify to the world at large, not only in India, but everybody operating on Indian airports as to what is it that the change is and what is the adoption that they need to do, and how the interface between the infrastructure, the airport and the airline, or maybe in respect of the standards to be maintained for operations, this interface will happen. Air traffic control is, of course, a very common thing, which is exchanged, because when you're traveling from, say, London to Delhi, you're traveling over 4 or 5 countries. You're within the jurisdiction, because technically, as I said, the airspace will belong to the country over which you will fly, and therefore this integration of the air traffic control management is also part of all these standards. Airworthiness of the aircraft, we have standard international procedures, and you hear a lot about what are the checks that you need to undergo. for an aircraft, we will have words like align maintenance, routine maintenance. You will have maintenance relating to, the C checks, where you just strip down the whole aircraft and then you carry out the maintenance. So these are all at certain number of hours. So these are all unified into an international system. Investigation of accidents, as again, obviously accident can happen anywhere in the world. Fortunately, we have a very good track record within India. But sure, there's nobody can predict it, and God forbid if there's an accident, you need a unified regime for investigation of the accidents. Then, as per Article 44, there are principles and techniques of international air navigation and air transport. So this obviously, as I said, to ensure safe and orderly growth of the aviation throughout the world. Art of aircraft design and operations to be encouraged, development of airways, airports, air navigation facilities, etc., flight safety, and generally the development of all aspects of national civil aeronautics. So this is obviously Article 44 covers is the Bible for the purposes of it's a very clear-cut guideline to every member state as to what is it that they need to adhere to in terms of international compliances in relation to operations of aviation. Then 44, what happened was that there was an international air transport agreement was signed in Chicago. And I'm sorry, I'm sounding a very historic, I'm talking in a very historic perspective. But then I thought this is very, very important to understand that what is it that the evolution of the laws relating to aviation took internationally and domestically. And we must understand these 5 freedoms of air rights, which is again an international issue, because you need to recognize the freedom of air rights. So for example, there is an understanding that if an Indian aircraft is flying over Pakistan, then you have certain protections. The right of the privilege in respect of scheduled airline operations granted by one state to the other state. So you will have, always recognition of the rights of another state with regard to operations in another state. There, and similarly, you will have rules of, these rules of air have been framed. First freedom, I said, is the privilege to fly across its territory, as I said. The second freedom is privilege to land within its territory. The third freedom of air is privilege to put down passengers, mail, cargo taken on the territory of the state whose nationality the aircraft possesses. The fourth one is to take passengers, mail, and cargo destined for the territory of the state whose nationality the aircraft possesses. Fifth is the privilege to take on passengers, mail, and cargo destined for the territory of any other contracting states, and the privilege to put down passengers, etc. So now the fourth one is in relation to where the aircraft is registered, and the fifth one is where it is traveling to. Now these privileges under the third, fourth, and fifth freedom of air rights relates only to services for routes which constitute a reasonably direct line out from and back to the homeland. The 5 freedom of air rights do not extend to scheduled international air services for any military purposes. Such privileges, are governed separately in areas of active hostility, and it can be exercised, and the privileges can be exercised only with the approval of the competent military authority. So there is where we bring in the dichotomy between the privileges in respect of civil aviation and privileges in respect of military operations. Coming back to India now, as all of you students know, that the fountainhead of all legislative power is the Constitution. which we always sometimes loosely call as Grundnorm. Now, obviously, you are aware that there are three lists: union list, the state list, and the concurrent list. And if we look at what is relevant from the perspective of aviation, item 29 of the union list covers airways, aircraft, and air navigation, provision of aerodromes, etc., etc. And 30 covers the carriage of passengers and goods by railway, sea, or air. So these are the two relevant entries. Now you'll find both these entries are in the union list. So only Parliament is empowered to make laws on aviation. I'll give you a simple illustration. Let's take a situation where and it happened in real life, the government, I'll give you an illustration, the government of Andhra Pradesh, then Andhra Pradesh, wanted to set up an airport in Hyderabad. Now, could they really set up an airport themselves? According to this, they didn't have the competence to pass any legislation allowing the setting up of an airport and carrying out activities relating to aircraft operation, air navigation, regulations of air organization of air traffic. And the logic for keeping all this in the union list is very simple, that there is such a vast international interface that you need to reserve this activity for the central government. And how could then the Hyderabad, Andhra Pradesh government set up that airport? What they had to do was submit a proposal to the Ministry of Civil Aviation saying that, look, you please come and we want an international airport in Hyderabad. Please come and do a survey. And pursuant to that survey, the Ministry of Civil Aviation granted a permission and approval for setting up an airport in Hyderabad. Of course, there would be distinct obligations. For example, provision of land would be done by this government of Andhra Pradesh, but the setting up of the facilities could be done by the government of Andhra Pradesh itself, or in this case, it gave it out to a private operator. But so far as the key activities of security, CNS, what is called a CNS, Civil Navigation System and Air Traffic Management, was reserved for the government. Customs was reserved, obviously, for the government. And safety and security, law and order. I mean, the local law and order outside the airport will be with the state government. But when it comes to the security within the airport, it will be within the union domain, being the Bureau of Civil Aviation Security. So that's how the division of responsibility has happened in development of airlines or airport infrastructure or anything relating to aviation. But the right, the concession, the right to carry out the activity has to be done either by the union government or under the authority of the union government. So that's how, so we need to be very, very clear, aviation is a central subject and only Parliament can legislate. Then came the first, so far as the independent India is concerned, Civil Aviation Conference happened in February 1947, and the Air Transport Inquiry Commission into the structure and working of the air transport industry which presented a bleak position of the industry in its report. In order to address the financial health of civil aviation, the Government of India passed and enacted the Air Corporations Act, which now stands repealed, obviously, because there are no Air India and Indian Airlines stand privatized. So all the carriers existing at that point in time, all the airlines were nationalized, and the Air Corporation Act was the legislation through which it was nationalized, and it gave birth to Indian Airlines. And then, of course, Air India was also nationalized, and 8 domestic airlines were nationalized. These were, the next slide, you will find Deccan Airways, India, Bharat Airways, Himalaya Aviation. Kalinga, Indian National Air, and Air India. So all these were taken over by the government. They became nationalized airlines, and there ceased to be any right within the private sector to set up an airline and operate an airline. But then with the liberalization, in fact, if we look at the liberalization of civil aviation industry, the whole process was much faster than the liberalization, which happened in the other industry post 1990. In 1994, that Air Corporations Act was repealed. And this allowed, because under this act, the activity of civil aviation was reserved for the government. This allowed the entry of private players, and then Jet Airways, Modi Luft, etc. came in, flourished. And then came the amendments in relation to aviation infrastructure. And then private domestic carriers started operating on overseas routes. Process of the privatization of airports was commenced. Then, of course, certain amendments were carried out in the Aircraft Act and rules, as well as the Airports Authority of India Act, for the purpose of enabling the investment by the private sector in the airport business as well. Privatization, which we also sometimes call as disinvestment, is obviously giving the asset, which is a public asset, to private ownership, or at least in some cases for operations, we call all these as different models, BOT, BOOT, and the like. It could also be, as I said, transfer of management. And this has been a subject of a long heated debate, but I can say with certainty, having seen the growth of aviation, this is something which has been the most advanced, most liberal regime in India. And that's how the private sector has been trusted. So you see that whenever the government allows private sector to come into a business which is reserved for the government, there are compulsions. The first, of course, being there is a perception in India, which to an extent is right, that the private sector uses the capital in a much more efficient manner as compared to public sector, which is not governed by the principle of profit, not driven by profit making, but is doing a public service, compared to the private sector, which is essentially looking at a viable operation. Precisely, we have seen how Air India went the way it went, and ultimately private sector had to come in. But the second aspect is that government obviously doesn't have the same amount of money to invest in these sectors, and they need private money to come into these sectors. And that's how, these are the two compelling reasons. But I'll give you an illustration. For example, in India, we have so many private airports today. It started way back in, I think, 2004, when the first privatization of the airports happened on a PPP basis. Even in a laissez-faire country like the US, you today have only one private terminal. I think it is a terminal in Austin, in the state of Texas, which is owned by a private airline. Barring that, even in a country like US, which is supposed to be most liberal in terms of private investment, all the airports are owned and controlled by the state counties. And so therefore, the government has not handed over this activity to private sector. As compared to that, in India, the whole regime is so liberal that, of course, as I said, 4 basic functions have been retained by the government, and rightly so. But the fact remains that the public sector, the private sector, the government, everybody has been so keen on development of the aviation sector that they have gone to the extent of saying that, look, if the government can't do it, we'll farm it out to private sector to assist in development of the sector. Then, of course, as you know, this investment was started of National Carrier Air India, and a reserve price of 12,000 crores was fixed. And Thales, private wholly owned subsidiary of Tata, bid for the airline, and they were successful. There was another bid by another Indian airline, and of course that is now history. Not very long, but just very short time back, we had this process having been completed. I don't need to spend time on this slide. Moving forward, I'll now go to the basic legal framework. If you look at the organogram or the regulatory authorities, organogram of the regulatory authorities, we have the Ministry of Civil Aviation. On the one hand, relating to airports is the Airport Economic Regulatory Authority Act, which governs the economic regulation and the returns on investment in the airports. You have the Aircraft Act 34 and aircraft rules made under the Act, which has two distinct bodies, the DGCA, which deals with the operational side approvals, and the Bureau of Civil Aviation Security, which only deals with the security at airports and aviation operations. And then, of course, you have the Airports Authority of India Act 94, which set up AAI. And AAI still has a very important role to play, even in private airport. For example, the civil navigation system and the air transport system today is controlled by the government through the Airports Authority of India. So when you land even at a private airport, the air traffic management, the tower, the control tower is still controlled by and under the authority of the Airports Authority of India. So somebody who's regulating a traffic sitting in a tower is essentially an Airports Authority of India employee, not employee of a private sector. So this is still a very significant role. Then we had on the airport side, the Economic Regulatory Authority. This set down the standards of which you are expected, and this again goes back to the ICAO requirements as to what should be the standards, the performance standards that your airports need to adhere to. And then, of course, it deals with once you have and this, mind you, this is applicable even to the public sector, even an Airports Authority of India airport, provided it is a major airport. It has, I think now it is 5 million passengers. If you are having operations relating to a major airport, you're subjected to this regulation, which essentially says, what will you charge the air? What will you charge the passengers? So there are two sides. There is a very complex regime there, which is identified as a cross-subsidized policy. Of course, there is a regulatory framework. There are three forms of economic regulations. One is the single till, the dual till, and the third is the light touch. So what we have adopted, I mean, originally the authority adopted the single till approach, wherein all your revenues are taken together and are regulated. As compared to that, the new regulatory philosophy, in fact, there is a directive by the government to ERA that you will follow what is called a hybrid till, where a 30% subsidization is permitted of aeronautical revenues from non-aeronautical. When I say aeronautical is the landing, parking, etc., etc. Non-aero is shops, hotels, eateries you have in the airport, plus whatever you can lease out in terms of your rights given to you, even whether it is a private airport or Airports Authority of India airport. So you need to cross-subsidize to make sure that the burden on the airlines and consequently on the passengers is cross-subsidized to the extent of 30% by non-aeronautical activities, non-aeronautical activities to ensure that things like landing charges, etc., parking fees is all within certain limits. And you can earn more on the non-aero side and learn less on the aeronautical side to reduce the burden on the passengers. The Aircraft Act, it provides the basic constitutional law for aviation. And it's a generic law which governs the relationships and obligations it deals with of the contractual parties. It lays down the regulatory framework for conduct of business operations of the industry. It defines aircraft, aerodromes, aerodrome reference point, import and export. Section 4 empowers the government to give full effect to the provisions of the Chicago Convention, and Section 5 empowers the government to make rules relating to regulation of air transport services. So these are the two very critical provisions, Section 4 and Section 5, which give powers to to the central government to make rules, and pursuant to which they have made rules of the aircraft rules of 1937. They apply to all aircraft in India. These rules set requirements for flying conditions, registration, airworthiness, licenses, training, etc., etc. Any airline which is supposed to start now, Akasa is going to start operations, and they have now submitted their documents to the Director General of Civil Aviation, which are called manuals. They're manuals for air safety, the manual for maintenance, the manuals for operations, and then there is a part 12 in B, Rule 133 empowers DGCA to issue special directions through issuance of notice to airmen, as I said, aeronautical information circulars, which is enforced by way of civil aviation requirements for use, operations, maintenance, navigation of aircraft. For example, there was a very interesting case, if you go through that, there was an issue which was raised by the residents of Vasant Kunj in Delhi. Their grievance was that they are in the flight path of the new airport at Delhi, 2911. And because of the noise generated by the landing aircraft, they are not able to sleep at night. And they demanded a night curfew. We were representing the airport operator. We obviously had a very strange situation to deal with, because there are countries in the world which prescribe night curfew, but then considering the necessity from, if you leave, because Heathrow is closed after 7 o'clock or 8 o'clock, then you can't take off from there, and every flight will land in Delhi at a time, or maybe land in Heathrow at a time which is not convenient to the airlines. So typically there is an argument also of discrimination vis-a-vis certain states, because conventionally, if you have noticed, most of the aircraft which arrive in India from international destinations in the West arrive at night. So this issue arose. DGCA was obviously seized. There was a public interest litigation. The DGCA had to intervene. They not only laid down certain standards in conjunction with the Ministry of Environment in respect of noise pollution within the airport, the DGCA also came out with certain measures relating to, for example, a thing like a vertical descent or a step-down descent for an aircraft. So these were typical situations which you will deal with, and all these civil aviation requirements ultimately are used to govern all these operations, and also modify the requirement of the local airports, local communities, and then of course the matter went right up to the Supreme Court, and certain preventive measures, certain remedial steps were taken by the airport operator. They constructed a wall on the side of the runway to protect the residents from on the other side of the road from aircraft noise. The other act is the Airports Authority of India Act, which of course manages the airports. And surprisingly, this act also defines private airports. So therefore, all the AI airports, for example, Delhi and Mumbai, are technically Airports Authority of India airports. So the AI airports, they have been given on a lease. Now, therefore, these are technically airports, AI airports. At the same time, in 2004, there was an amendment to the AI Act, which enabled private sector to take shares in airports. So AI, as I said, apart from having certain role, say for example, in the civil aviation, in the CNS ATM operations, they also have the certain airports which have been reserved for them. So how they deal with them on their own, or how they allow the private investment to come into these airports, is governed by things like the Airports Authority of India Act amendments relating to, for example, private airports. And it also enabled the AI to take shares in private airports. Ministry of Civil Aviation is obviously the ministry, and I mentioned the Airports Economic Regulatory Authority, which deals with the economic regulations of airport. I will not spend much time on this. The DGC I've also already mentioned. I'll run through this because we are running against time. The other part is this civil aviation security, which is reserved for the central government through the Bureau of Civil Aviation Security. So you can only have, and BCAS, for example, at the airports, you will find that BCAS has the regulatory control, and they do it through generally the security the mechanism which is under the BCAS, and they have engaged various authorities with carrying out security at the airports. Then, of course, I have already dealt with AI, is to accelerate integrated development. I will not again delve into this further. And then the recent steps which are within the policy domain is the National Civil Aviation Policy. This is an integrated policy launched in 2016 for taking flying to the masses by making it affordable, convenient, and enhancing the connectivity of the regions. You have Ude Desh Ka Aadmi, which is popularly known as UDAN, to facilitate and simulate regional connectivity, which is within the region itself, rather than, conventionally the aviation development has taken place in bigger cities and tier 2 cities at the most. In the last few years, we have seen a movement to even places like Jalandhar, places like Kushinagar in UP, which has a lot of connectivity is a big issue, where connectivity is a big issue. Then the next generation of airports for Bharat, it is called NAHB, Nirman. It was launched in 2018 to build billion trips airports capacity. Digi Yatra policy, again initiated in 2018 to develop standards for digital processing of passengers at airports. 6 brownfield airports have been privatized: Lucknow, Ahmedabad recently. I'm talking of recent steps. I'm not talking of something which happened in 2005 and 6, which was the first phase of privatization. So Lucknow, Ahmedabad, Jaipur, Mangaluru, Trivandrum, Guwahati. New policy for maintenance of repair, the new MRO facilities. MRO is a very critical component of civil aviation operations, which is the maintenance, repairs, and overhaul of aircraft. New policy has come in to make India global, because you will be surprised that most of the aircraft, even operating in India, are today either maintained in the Air India facility, or they went to places like Sri Lanka and Dubai for major maintenance. Routine maintenance is, of course, done at the airports themselves, which we also call as line maintenance. the DigiSky platform to bring different agencies to same platform to enable registration of drones. We have heard a lot about the drones today. Real-time tracking, conflict management, water aerodromes. Of course, you have very little information available in the public domain, but this is something which is still in very nascent stage. Water aerodromes is something we do not see coming up very shortly, but in a midterm, this is something which we'll also see. So Krishi Udan scheme to assist farmers in transporting agriculture products. IFSC is another very significant development to bolster aircraft leasing and financing ecosystem. IFSC, as you see, is an artificial structure created outside the taxation system of India. So institutional arbitration center has come up in Gift City, and some operations relating to, or some activities related to financing and leasing of aircraft has taken baby steps in IFSC. Extra credit line guarantee scheme, which started in May 2020 as a part of the Atmanirbhar Bharat Abhiyan. It relates to financial guarantee for industries disrupted by COVID-19, and obviously it has been extended to aviation. Drone Shakti, I think you've heard a lot about the drones. And so this is broadly the legal and regulatory framework, the policy framework in relation to aviation. I'm sorry, I've been very kind of gone back into history, but I thought that it is very important because this is a capsule which would give you that where the civil aviation journey started from a legal and regulatory perspective and where it is today. I hope this will be helpful. Thank you for your patience.
Thank you so much, sir. It is always profound to hear from you. I think you started by saying that you may not call yourself a master, but I think only a master can take us back to the foundation. And as Professor Aggarwal also said that, one should have a foundation which is well built. So I'll thank you, sir, for taking us through this entire journey right from 1911 to where we are today. So I'll just take one question, sir. I guess you've spoken about IFSC. There was a question about IFSC, and you've given us a lot of illustrations about airports. There was a question about what are appropriate forums for settlement of ERA-related or tariff-related disputes.
I think you see there are three levels to it. The Airport Economic Regulatory Authority, which first sets down the tariff based on the economic principles and the proposals submitted by the airport. So they rely on the building blocks with regard to the costs that have gone into the establishment of the airport and what is the return on that investment. This finding can be challenged before the Airport Economic Regulatory Authority Appellate Tribunal, which currently is being housed in the TDSAT, which has been given the powers under this act, and however they also exercise their original powers under the telecom regulations. So that is the regulatory tribunal, and from there lies a statutory appeal to the Supreme Court directly to decide all these issues.
Thank you, sir. Thank you for this very informative session, sir. Very insightful. Thank you.
Thank you. Pleasure.
Thank you so much, sir.
Now we would like to get on board Professor Reddy.
Hello.
Hi, sir. Good evening.
Good evening. Good evening.
Good evening, sir.
Good evening. Good evening, Neha.
So, sir, we will just introduce you for our panel of participants and members, and then we'll roll it over to you, sir, for taking over the presentation. So, just for everyone, Professor Reddy teaches LLB and LLM courses at NALSA, Hyderabad, which amongst others include topics like international law, international trade law, international air and space laws, international intellectual property law, banking and insurance laws, comparative, cooperative and competition laws, international environmental law and international humanitarian and refugee laws as well. He has more than 15 years of teaching experience. Professor Reddy is an internationally recognized expert in air and space law and has contributed valuably by his paper on aerospace technologies and problems of third world countries, and the application of satellite technologies in civil aviation, emerging legal issues, which he presented at the Unispace 3 conference in Vienna. He's also a visiting faculty member to many universities in India and abroad. He's engaged in various prestigious projects and assignments, which include the WTO in India, issues and challenges, drafting of model space legislation for India, and sensitization program on WTO GATS, and globalization of legal profession, opportunities and challenges for Indian legal fraternity. Before you start on, so I'd like to add, we've had the opportunity to read a couple of books that you've personally authored, and we've had a fantastic read of it. I'll hand it over to you now, sir.
Okay, so I'm trying to open my video. Okay, yeah. So, okay. So good evening, everyone. Can you see me?
Yes,
we can see you, sir.
Okay. So good evening, everyone. Thank you, Neha and his team, her team actually giving me this opportunity. So I'm going to talk basically private air law, that is Warsaw system, or more particularly Montreal. Before that, I just 2-3 minutes I'll take about, why and how air law or aviation regulations. That is what I'm going to do that. When I say why air law, so I know today, tomorrow, day after, we are going to talk about all these things. But one basic question comes, do we need air law to regulate aviation? Yes. Why we need? Because aviation carries over 4 billion passengers annually. Friends, I'm giving you these statistics of 2019 because you all know that COVID, I call it a COVIDization. COVID has impacted the global governance, all sectors, and more particularly aviation sector has set back. That's why I'm giving the statistics of 2019. So 2019, if you look at, annually, the global aviation carriers carried 4 billion passengers. And every day, if you look at 120,000 flights depart, carrying around 12 million passengers per day, along with 18 billion worth of trade. This can't possible without regulation, without law. That is the point what I want to put here. Global air transport sector, you all know that, supports 65.5 million jobs. This is very interesting thing we have to make note. And it also contributes 2.7 trillion global, economic activity. And I can tell you, any given moment, if you look at 10,000 flights fly across the globe, and everybody has to follow same rules. That is where the regulations or air law comes into picture. That's the thing. And of course I can go on talking about the other things, but primary why these are reasons. How aviation regulations can be happen. Of course, I'm going to focus more on one aspect, but before talk about aviation regulations or air law, you all know that it's a body of rules governing the use of airspace. Of course, friends, airspace is different from outer space. You all know that. That's why I'm talking about airspace. So this body of rules, if you look at, if you analyze, there are basically 3 important aspects of, if you ask me a question, sir, tell us in 2 minutes about international air law, I can tell, saying that, entire air law is based on the philosophy of international, I'm talking about, philosophy of who owns the land, owns the sky. Usa esta solam esta esque et coelum. That is the Latin maxim. But who owns the land, who owns the sky. This is the philosophy of air law, and it more particularly applicable to all regimes. And if we had to analyze in very brief manner, entire air law can be looked at understanding of 3Ps formula. You know what is 3Ps? PPP. Of course, PPP nowadays people know about public-private partnership, more very used word. But I can say, tell you friends, PPP used, public air law, private air law, penal air law. So public air law deals with the Chicago regime. Of course, other speakers are there going to talk about that. But just in a minute, I want to give, public air law, or what we call Chicago regime, deals with general and, technical aspects of, aviation regulation. Of course, we have a Chicago Convention. Before that, aviation. Of course, law and technology goes together. You all know that, the moment when, Wright brother invented aircraft, And in the same month itself, global, players, particularly some of the European states, started talking about the regulation. That is where the birth of technology and law goes along. And most of these regulations identified with the Chicago relating to technical and other general regulations. What I call Chicago regime. Chicago regime consisting of the Chicago Convention and the other conventions dealing with the general and technical aspects. Of course, I am not going to focus on, but just this is for your information. Second is Warsaw system. Second P is, first one is public air law or Chicago regime. Second is private air law, or what we call liability regime. Private air law, also called, you all know that, conflict of laws. Our Warsaw systems deals with the liability. So again, to put it, Warsaw system consisting of the Warsaw Convention 1929 and other conventions and protocols dealing with the liability issues. I'll dwell little, elaborate later on. So this is the second P. Third P is penal air law. Okay, that is called, safety security, mostly deals with safety, air security, all this. So this is what I thought, I'll say why air law and how, the international air law. So aviation regulations, if you look at, friends, broadly, every country, national regulations, bilateral regulations, regional, global. So of course, I'm going to focus more into global or international air law. I said understanding international air law can be understanding 3Ps formula: public air law, Chicago regime, private air law, Warsaw system, criminal air law, or what we call the penal air law. That's it. So, and I think all these regimes, whether you talk about Chicago or Warsaw or any convention, the basic philosophy which I just mentioned is the who owns the land, so owns the sky. That is the point which I want to elaborate. Then, of course, since I'm going to talk about Warsaw system on aviation liability, or it deals with more particularly Montreal Convention. So, what do you mean by Warsaw system? Okay, Warsaw system. When I use the Warsaw regime, I call it because it's a broad word we used. Warsaw regime consisting of the Warsaw Convention 1929. And other conventions and protocols. You know what is a convention, what's a protocol, okay? So other conventions and protocols dealing with the liability. Liability of whose liability we are talking about? Liability of passengers, cargo, and destruction, damage of cargo, delay. Those things comes into Warsaw system. Of course, plethora of international treaties which deals with Warsaw system. Particularly the moment when I say Warsaw system, I had to mention Warsaw Convention. Warsaw Convention is the mother or important treaty dealing with the issues pertaining to the liability particularly. Of course, though, when I say Warsaw Convention, it is way back in 1929. 1929, 1920s, aviation was very, very rudimentary or not so developed that. So, but still, that convention actually dealt with the liability issues or private air law. So, after 20s and First World War, Second World War, these are all, prompted to go for Warsaw Convention. So, but one thing relating to Warsaw system even now also is that, low liability system. Warsaw Convention way back in 1920, because if I had to talk about Montreal, this I had to give, 2-3 minutes background about the Warsaw, because Warsaw Convention is the source for Montreal. So this 1929 convention basically deals with all liability issues relating to that. But one issue, Warsaw Convention fixed the liability for passenger like 1,25,000 francs. Franco, it's a French currency because 1920s. So at that time it was around like $8,000. But other things also it discussed issues relating to baggage and cargo, other things. So that's the Warsaw. But friends, one important developments happened. You all know the law is a dynamic and air law is more particularly dynamic in nature. So it is changing from time to time. So because of the liability regime is changing, so the international community came out with other conventions and protocols. And when I say protocol, friends, protocol is the supplementary to the convention. Okay, we have a Hague Protocol 1955. This is a very important thing. Some developments happened after 1929 to 1955. So much development happened. To incorporate these developments, they came out with one protocol that's called Hague Protocol of 1955, which changed the Warsaw Convention. Mainly, enhancing the liability regime of passengers from 1,25,000 francs to 2,50,000. It's doubling that thing. It's around like again $16,000 if you put it that. So that was the major development happened, and then later on again from the beginning in the Montreal or Warsaw or liability regime is different between the developed and developing countries. Developing countries, developed countries always in favor of more enhanced liability regime. We developing countries were not supported that cause. That's why developed countries were not happy with the existing liability regime. So that's why they increased from 1,25,000 to 250, and still they were not happy. So more particularly America. So because America was not happy, and by the time 1960s, early 60s, America threatened to actually I want to withdraw from the Warsaw system. That kind of threats came, and then to pacify, to satisfy, to appease the so America and mainly particularly USA. So the international communities came out with one international treaty that's called so-called Montreal Agreement of 1966. Why I'm using so-called? Because it's not an international treaty. It is an arrangement. It is an arrangement to satisfy the US issues. That's why it called so-called Montreal Agreement of 1966, enhancing the passengers' liability again like $1,75,000. So that including the attorney fee, or if you exclude attorney fee, it was like $58,000 in 1966. I think it's a very rarity in international conventions talking about the attorney fee. This is a convention which talking about attorney fee, including excluding. That shows how aviation lawyers have got important even in those days. That's what I want. So this Montreal Protocol is nothing but just to make happy America, but not many countries accepted. And then other developments in 1960s and 70s particularly happened, various protocols. But in 1975, one important development happened in the aviation liability regime is the protocols. That's called 4 Montreal Protocols of 1975. These 4 Montreal Protocols are nothing but changing the US dollar. Actually, earlier I said francs. It was a French currency that was created a lot of problems. Then changing from francs to SDRs. SDRs, you all know, friends, it is a IMF, special drawing rights. It is a monetary denomination of IMF. So they changed from first protocol talking about the changing from 1,25,000 into like 8,000 SDRs. Like second protocol talking about changing from like 16,000 SDR is equivalent to dollar in those days. Now changed. So this is the thing, and these are all of course problems. But still the developed countries were not happy with the liability regime. That's why the Montreal Convention of 1999 came. Okay, so divided. The world is divided between developed, developing countries when it comes to liability regime. So to again, lot of issues happened with the developed countries. They were not happy. So that's why a comprehensive revision required, needed. That's why Montreal Convention 1919 is nothing but updating the Warsaw system on the liability, whether it's for passenger or cargo or damage to destruction to cargo, baggage, all those. Today liability under Montreal Convention 1919 is nothing but updated, amended, revised version of the various liability regimes pertaining to the civil aviation sector. So today, if you look at liability, $1 lakh US. So that is the change they made it, and of course they enhanced liability of baggage, liability of passengers, and except one thing which not changed from 1929, that's the Warsaw Convention till today, is the cargo. 17 SDRs that was there in 1929 today is same thing, except that other lot of revisions happened and regimes have changed. So this is pertaining to the liability regime in general, and lot of new developments which the Montreal Convention brought, including enhancing fifth jurisdiction, enhancing the incorporating the insurance liability. Then it also enhanced the passenger liability, not only passenger but cargo, and also these new developments which incorporated in the Montreal Convention of 1999, keeping in view of the changing scenario. Of course, you all know that India is a party to all these international air law, whether it's the Chicago or other conventions. So India is a party to all these international treaties, and we incorporated these conventions into domestic law. Friends, you all know that international law or international air law has a limitations. The problem when you look at the domestic law with international law has some limitations, because international law deals with sovereign states. It is a law between sovereign states. So just to give a 1 minute idea, yes, not automatic. So when we look at international treaty, whether it's a Montreal or Warsaw or Chicago, how we implement in India, Indian context, if you look at, yes, we implement incorporating those international treaties into the domestic scenario. India follows the dualistic approach, what we call, we recognize that international law and domestic law are two different distinct bodies. If we have to implement international law or international air law or Warsaw or Montreal Convention, we have to adapt. So that's where we have dualistic approach, or then we call adoption theory. India follows specific adoption or transformation theory. Part of that, India, of course, party to all these international treaties, and we have domestic laws dealing with these international conventions. Particularly when I say that earlier we used to, India was up to Warsaw Convention 1929 and Hague Protocol, we have Carriage by Air Act 1972. But now the Carriage by Air Act is replaced 2009, incorporating the Montreal provisions, because India was the 91st member in ratifying the convention. So this is the one area, just I thought I'll just update that. So then other aspect, because my title goes applicability, adoption scope of Montreal Convention, concept of liability, and other issues relating to the professional aviation professionals, scope and opportunity. Of course, today new developments are happening in the aviation sector. That is true with other sectors. Particularly, we hear about a lot on the globalization, liberalization, privatization. All these things are happening across the globe, and aviation sector is no exception to this. So globalization, of course, happening in all sector, I said just now, and more particularly in the aviation sector, it began with, Air Corporation Act 1978 in the United States, and, then it moved to Europe, Africa, America, all continents today, almost all the countries now, part of the globalization or global. So globalization impacted aviation sector, there is no doubt, because of the growing, international economic, cultural, political, economic cooperation. All these things have, a lot of impact on that. So without doing into the, details about that, how India is, implemented this globalization process. Of course, when I say globalization, India is no exception to this. So India incorporated this globalization process. India, we all know that, friends, in 1990s, early 90s or 1991, we liberalized our economy. Okay, we call it say liberalization. Some countries say liberalization, deregulation, privatization. These are different terminology we use, but in India, the globalization process has been percolated to the Indian domestic context by incorporating a lot of changes in the global general Indian economy. So this happened. Why India has to globalize or liberalize the economy? You all know that mounting problems of financial debts, balance of payment crisis, foreign exchange, all these things which necessitated to become India part of the globe or global economy, and India took that. But aviation is part and parcel of the general economy. So the moment when general economy was liberalized, and then Indian aviation sector also started liberalizing, and the liberalization of Indian aviation sector started in, of course, mid 80s. It started with cargo, then we moved to passenger, all these things. So the impact of aviation on Indian sector began with the cargo, then passengers, and why we need, how we liberalize, we all know that. I'm not going through that, but today, because I have to talk about the prospects, that's why I just brought this, idea of globalization, liberalization, privatization, deregulation, what you call in other parts. So India is incorporated these changes, and now in the tech sector, any sector you take, whether it's the liberalization, open sky policy, we call it in India open sky policy, repealing the Air Corporation Act 1953, and again, we have a new Air Corporation Act 1994. Then airports, if you look at airport privatization, of course, I use here PPPs, lot of public-private, partnerships happening in the airport, and we have a Airports Authority of India Act, and privatization of AIA, again, incorporating various provisions. In the same airline privatization also happened, liberalizing FDI in aviation sectors, mergers, acquisition, competition. All these are all the new challenges which happening, and particularly what kind of opportunity we in India have in the aviation sector, or if I say scope of civil aviation growth. You all know that the aviation industry in India experiencing new era of expansion because of diversified factors such as low-cost carriers, modern airports, foreign direct investments in domestic airlines, cutting-edge information technology. These are some of the positive factors for aviation growth, and these are all again, contributing to the growth. So this is, and if you look at most of the time, I say that population is a liability. But friends, I can tell you when it comes to aviation sector, the population is an asset. Why I am saying this? Saying because the 1%, for example, today we have 130 or 140 crore population. If 1% of the population tilt towards the other modes to aviation, we need hundreds of aircrafts, hundreds of airports. Do we have these? So this is where challenge comes and opportunities lies, I can tell you. So that is where the whole global aviation industry is eyeing on India, because of the potential which India has. When I say the potential which India, because of population, and today everybody is cautious about their timing and other things. So there is no doubt, of course, we have had problems. I'm not saying that, all went well. No, we till recently, if you look at unfortunate thing about this great country is that we do not have had a aviation policy. How can you expect investments come and, investor can invest here? So of course we have a 2016 aviation policy to some extent, that is filling, and we need to have a more and more, but those were some of the hurdles we faced, and today things are changing and a lot of new schemes. Other, speaker also spoke about that. These are things which are happening. Keeping that in view as an academician, and I can tell you that, there is no doubt opportunities are there. Global, aviation world is eyeing on India. Not that they like you, but they have a selfish interest. The selfish interest is nothing but, they have a lot of scope to invest in Indian airports or airlines, all these things, because they saturated, whether you take US or Europe, all saturation has come, but when it comes India, everything is new. That is where the lot of scope, opportunities are there, and keeping that in view as part of the academician or, professor of law, what I call is academic social responsibility. You all know, friends, actually earlier we used to talk about a lot on the CSR, corporate social responsibility, part of the 2013 Act. Now it became, part of the Companies Act 2013. But now I'm, talking about, CSR versus ASR. What do you mean by ASR? ASR is nothing but academic social responsibility. The part of the academic social responsibility, being India, emerging player, and also Nalsar is one of the top law schools, second or third, whatever. So we design certain courses keeping in view of the future requirements of the aviation industry, and I can share with you in a minute or two. So we have designed some courses like, combining law with the technology, law with the management. Today, we are living in an era where the interdisciplinarity will work. Single, either law or technology won't work. That's why we in Nalsar have designed some courses, keeping in view of this interdisciplinary approach, online courses, then, using the technology. So combining law and management. When I say law and management, so these are the courses. If you look at aviation, start with the basics of, law, like introduction to law, the international air law, domestic air law, liability law, like that we have a design. Similarly with management also, like basics, principles of management to airport management, airline management, airspace management, air traffic management, because we need, unfortunately, aviation education is not there in India. That is what, prompted us to think about, and we are, this is accessible to affordable and accessible. Our approach is to aerospace education at the doorsteps of the needy with affordable cost. This is our thing, and we are offering these courses. This is what I call it, say, again, academic social responsibility. If you say that NALSAR is the best law school, what is the contribution of NALSAR to the aviation sector? Friends, we have a full-fledged department. I think, subject to correction, this is the only department, in India, full-fledged working on the aerospace defense laws, and, particularly aviation sector. We have a master's program, diploma programs, and other certificate programs. All these things last 6-7 years we are offering. So with this, why I referred this is, we have definitely, there is no doubt the scope and opportunities are, ahead, and we have to prepare to take that challenge or that kind of opportunities. That's the point I wish to, put forward here. And thank you for giving me this opportunity, everyone, particularly organizers. Thank you. And any question, I am happy to again respond to that.
Yes, sir. First of all, sir, thank you for the wonderful and this instilling information all about the protocols, the new definitions for PPP. One will always remember, and commendable job, sir, at the initiative that you're taking with the courses that you've designed within NALSA for aviation law. Very, very commendable, sir. Just a couple of questions, sir, that I will take. So there are just a couple of questions. For example, someone had asked, what are the various defense pleas that can be raised by the air carriers under the Warsaw Convention?
Of course, and defense, civil aviation is completely different from the defense aviation. Defense aviation is different, and because that comes part of the Ministry of Defense. Though the Chicago Convention or liability, all these things only related to the civilian sector, not applicable to the defense. We have a separate laws to deal with defense. We have Air Force Act, Army Act, Navy Act, Coast Guard Act, all those. So that is a completely different thing. But there are certain issues, challenges which we are facing in, for instance, airspace management, air traffic management. Today, the issues which are happening within the country is that how to manage airspace, like defense airspace and civilian airspace. This kind of issues coming, but when it comes liability, complete liability is a different domain. And India being a party to the Warsaw Convention and Montreal Convention, we are implementing through our domestic legislations, friends. So defense laws won't figure into the civil aviation sector. That's my.
Right. Thank you, sir. Just another question, sir. Someone has asked, Pratyuman has asked, is there a difference in protection of carriage of goods in the Warsaw regime under the air law and the CISG rules like the Vienna Convention under maritime law?
Yes, there are different rules. This deals with, like I said, Warsaw Convention or Montreal Convention, deals with what? Liability. Liability of whose liability we are talking? Passengers liability. Injury or death of passenger. Other issue is cargo. So coming to his question, actually, we have a cargo. So delay of cargo, destruction of cargo, damage of cargo, all these things part of the, I can say that Warsaw earlier and present thing. So we have, so if, destruction or damage happened, what is the liability? Like 4,000, US dollars, SDRs, like we have said. So this is only when you have a cargo, air cargo. That's what, when it's something, relating to air cargo, this is the regime which deals with, that. So PP is very well defined in this perspective. Okay. Somebody was asking something PPP. Of course, I said PPP in different contexts, just to remember, if somebody is new, this thing, I said, you can remember if I say public air law, private air law, penal air law, easily to remember, I use that word. But otherwise, definitely PPP is today only deal with, public-private partnerships. Okay.
Yes. Yes, so I'll just pick up one last question. So Shaurya has asked us, whether air acts were repealed at the time of liberation
Hmm.
of the industry.
We have done. Unfortunately, one thing is if you look at domestic air law, we begin with Aircraft Act 911. But of course that was no more. Aircraft Act 1934 is the legislation, the master. If you say that I'm using the word the or important legislation, though title is that Aircraft Act 1934. But if you look at, friends, we have done so far 9 amendments, major amendments relating to incorporating the changes. You may ask questions, sir, why if every time when new amendments are happening, why we keep 34? Of course, Indian Evidence Act, all those, we have a British legacy, we keep that, but we are amending, updating in tune with the global and domestic developments, and we incorporated in the domestic law. Aircraft Act is the master or importantly, and different regimes specific. For example, liability. I said carriage by air act 1972. Today we have a carriage by air act 2019 because India is a party to the Montreal Convention to update that. Like that, if safety security, I didn't talk about, like we have a safety, Tokyo Convention, Hague Convention, Montreal Convention, Montreal Protocol. To deal with these international conventions, we have a Tokyo Convention Act 1975, Hague Convention Act 1982. Then we have a, these are other legislations we India incorporate part of the international treaties.
Thank you so much, sir. Thank you so much for taking these questions, sir. And thank you for this wonderful, wonderful presentation, sir, today.
Thank you. I hope I am on time, and I thank you
yes,
very
sir,
much.
Absolutely.
Thank you, sir. This has been an absolute pleasure, and I have been interacting, following you for a very, very long time, and this has been absolutely incredible. My takeaway is going to be the academic social responsibility, the new terminology. I think we are taking a few with us, and look forward to collaborating with
Sorry, Neha, recent past I am doing a lot of writings on the CSR versus ASR. If you look at academic social responsibility, if you want somebody to read, because now it is everybody's responsibility. I'm sorry, 1 minute I'm taking. It is an individual responsibility. Then it goes to institutional responsibility. What we are giving back to the society. So that is where the new term I am using, the academics, social responsibility. We are all part of that.
Yes, sir. This is absolutely fantastic. It's a key takeaway, and of course, we, like you said, we have to contribute back to the society, and there is no better way of doing it. Considering we are all connected, the industry academia connect is definitely what we look forward to achieving in times to come. And thank you once again, sir. This has been incredible.
Thank you, sir.
Thank you, sir. Okay. Thank you, Kashish.
Over to you now.
Thank you. So, friends and attendees, I'm so sorry we could not take the coffee break. You guys could not have, grabbed your any bit of break or get your coffee or your parathas or whatever. I'm so sorry for that because we are slightly outstretched on time. So we have our last speaker with us, and we're going to speak on a very interesting topic of public air law. And let me just introduce and start with the session. Professor Stephen Truxell holds a BA in International Affairs with concentrations in International Law and Economics from the George Washington University in Washington, D.C., an LLM in International Commercial Law with focus on international transport, and a PhD in Air Law from the University of Westminster in London. Professor Truxell also has a track record of research excellence in air law. His PhD dissertation was later published as Competition and Regulation in Airline Industry, Puppets and Chaos. Professor Truxell's second monograph is entitled Economic and Environmental Regulation on International Aviation from International to Global Governance. Professor Truxell joined Leiden from the City Law School, University of London, where he was Reader in Air Law and Associate Dean. Previously, he served as visiting professor of law and dean of studies at the Center for British Studies, Humboldt University in Berlin. He has also spent time as visiting researcher at the McGill Institute of Air and Space Law in Montreal. Prior to his academic career, he has gained experience through working in the aviation industry with the Deutsche Lufthansa AG in government administration at the US Department of Commerce. I don't think we could have had any person better than him who could explain to the the students and the professionals alike the importance and the coverage of public air law. With that, the floor is yours, Professor Truxell.
Thank you very much. I will just share my slides with you. If I can get it to work. There we go. Thank you very much for that kind introduction. And I'm joining you here from the Netherlands. But I have to say that my last international trip that I took before the COVID pandemic was to India. And while I was there, I visited the National Law University in Delhi, and I was given a copy of the Constitution of India. And what we're talking about today is what I'll be talking about is the Chicago Convention 1944. And this is in many respects the constitution of international civil aviation. Just to say also that on our program that we teach here, which is an advanced LLM in air and space law, at the moment we have about 25 students, and 3 of them are your fellow countrymen from India, two ladies and 1 man. So let's get started. So once upon a time, there was the view that, taking from the Latin maxim, which goes, "Huius et solum, ius et usque et colum et ad inferos." I don't expect anyone speaks fluent Latin. I surely don't, but it effectively translates to, whosever is the soil, it is theirs all the way to heaven and all the way to hell. In other words, owning land, terra firma, the sultan, the king, the queen, is then has control of all things, all the way to the heavens and all the way to hell. Well, of course, this has an impact for airspace, and that maxim didn't last very long. By the time we got to the technology advanced to have air travel. But before we even had aircraft, of course, we had balloons, which were being used, hydrogen balloons, for hundreds of years. But if we fast forward to 1903, we know about the Wright brothers. So this is a good example. They didn't fly very far, but showed that this was possible for passenger transport. And in that same year, 1903, we had the Frenchman, Paul Fouchille, who suggested that airspace should be limited in terms of altitude to 500 meters. Now, the Eiffel Tower in Paris at that time stood at 300 meters. So to some extent, that was, I mean, much higher than the Eiffel Tower. Surely that was not, we were not to go much higher than that in aviation. Well, we know that's not the case nowadays. But just to give you some context there about the earliest talk, if you like, of aviation law, or the limits of aviation. Well, following World War II, we had the French government invite delegates from around the world to Paris to a conference on air navigation. And at that conference, they agreed to a draft convention. And this is an important starting point for public international air law, because it's our first ever international convention in this area of public air law. You've heard from Professor Reddy about the Warsaw Convention, which of course came in 1929, so sometime later. So this is our very first piece of international law in this area. Anyway, there are 2 takeaways from the Paris Convention. One is Article 1, which says that the high contracting parties recognize that every power has complete and exclusive sovereignty over the airspace above its territory, and goes on to say that this is, of course, in a colonial context, 1919. So it goes on to say this includes territory of the national territory, that is the mother country, and of the colonies, but also to the territorial waters adjacent to those land masses. This is quite important because it recognizes, you know, it doesn't say establishes, but that the parties at that time recognize the concept of sovereignty, state sovereignty, that is the freedom from outside interference with one's domestic affairs and so on. So that's one takeaway, sovereignty as a guiding principle of aviation. The second takeaway is ICANN, which is the International Commission, or was the International Commission for Air Navigation. We now have the Air Navigation Commission, ANC, but anyway, this is our very first body in this area, for dealing with air navigation and the issues. And it was established by the Paris Convention. So it's been around for quite some time. And you can see from Article 34 there, who is part of this? Well, the Permanent Commission was placed under the League of Nations, which of course is the precursor to the United Nations. And just if you see there, 2 representatives from the US, 2 from France, 2 from Italy, 2 from Japan, aviation powers of the day, 1 representative from Great Britain, 1 from each of the British dominions, and 1 from India. And then 1 representative from each of the other contracting states. So you can see already from 1919 sort of who are the power players there. And of course, India is at the table from the very start. So if we fast forward to, well, through World War II, which of course didn't end until 1945, it's interesting that the US government, seeing the end of World War II in sight, invited delegates from, again, around the world to Chicago this time to put together a new convention, which was slightly more detailed. This convention opened on the 7th of December, 1944, opened for signature. And again, an Indian reference. India was there and signed on that day the convention. It was ratified in 1947 alongside other countries like the UK, US, and so on. And the convention entered into force in 1947. So well after World War II had ended, this convention was ready, it was in force, and we could proceed with the sustainable and orderly development of international civil aviation operations. So I don't know if you can see from the slide there, what is the big change between 1919 and 1944 in Article 1? Well, there's only 2 things really: high contracting parties to contracting states, and also the spelling of recognized has changed from the British spelling to the American spelling. Now, the Chicago Convention established initially the preliminary International Civil Aviation Organization, which became the International Civil Aviation Organization. And this is one of 2 UN specialized agencies that exist. The other is the International Maritime Organization, which is based in London. But the ICAO, as we call it, is based in Montreal. And at the moment, we have 193 contracting states. So effectively, the entire globe is covered. You can only be a member if you are a state. So like the European Union is not a member, ASEAN cannot be a member, and so on. But they are observers alongside the industry representative bodies, like the airline representative body, IATA, the International Air Transport Association, or the body that represents airports, or the body that represents air traffic controllers, and so on. So they are represented through their member states, right, and the airlines of the member states and so on, but actually they're observers, so they stand at the back of the room in the plenary. The next General Assembly, they happen every 3 years at ICAO. The next one is coming up here at the end of September, first week of October. And it's important just to note here that India's role, again, very important role at the moment. India is sitting on the ICAO Council, which of those 193 states, there are only 36 which sit on council and are permanently based for 3 years, for a 3-year term in Montreal. And India is there, and currently the council member for India may be a name that's very well known to many of you in India, Dr. Shefali Juneja. Article 2 of the Chicago Convention, a little like the second part of Article 1 of the Paris Convention, says that the territory is both the land areas and the territorial waters adjacent thereto, under the sovereignty, suzerainty, protection, or mandate of such state. In other words, when we talk about the airspace above the territory, we also extend it outwards to include the territorial waters. And we call that, well, 12 nautical miles from the coast. Now, this is interesting because now I'm talking about water. And so from air to water, of course, we rely in air law very much on maritime law. And notably the UN Convention on the Law of the Sea, UNCLOS. And I won't go into detail on this, but you can see reference to the sovereignty of a coastal state like India beyond its land territory and its internal waters, rivers and lakes and so on, extending outwards to the territorial waters. And then where we have an archipelagic state, like the Philippines with many small islands, it covers that entire area. And I have some maps on the next slide, which will show you how that works. The second point is the sovereignty extends, therefore, over the airspace above the territorial sea, as well as to the bed and subsoil. That's not so relevant to us in air law. So here are some pictures. On the top left, you've got the European Union, more or less. Well, there's also Turkey there and EEA, anyway, Europe, broadly defined. And you see the yellow bits are the land areas. And then you see the kind of orange bits, which are the territorial waters. And then you see this turquoise color, not quite light blue, but turquoise, which are the exclusive economic zones. And there's a bit of a question then in law about economic EEZ or exclusive economic zone and airspace. How does that work exactly? Well, in the bottom right, you'll see how that works. You have the national airspace, which extends over an archipelagic state, like the top right corner, Philippines. So extends over all of those waters, internal waters, and also includes the territorial sea. So we have then from where the exclusive economic zone starts, which means in maritime law that states have certain rights to fish. Of course, we always say, well, fish move. So we have to account for this somehow. So the exclusive economic zone is not only in fish, but also in oil and other things, minerals and so on, resources in the continental shelf. The point for us in aviation law is this is all international airspace. Yeah, some of that is under the EEZ, which have maritime, rights and so on. But then we also have the high seas there. Okay, and here's another nice archipelagic in your neighborhood, sort of, which is Indonesia. Again, huge national sovereign airspace because there are so many islands. And so we take the internal waters between all the islands in Indonesia, we circle it off and we say, this is the sovereign airspace. And then we add 12 nautical miles and we say, well, that's the territorial water. So all of that is the territorial sovereign airspace of Indonesia. So we've established how wide it is. How high it is another question. And I saw some questions coming in the Q&A beforehand about space law. Well, this is an age-old question. Where is the boundary between airspace and outer space? Suffice it to say that some agree that it's around 100 kilometers up, although commercial aircraft are not flying so high. That's maybe for another day. Okay, so over the high seas, all states, whether you are a coastal state or a landlocked state, you have the right to access the high seas by boat, by ship. You have the freedom of navigation, and that freedom extends upwards to include the airspace over the high seas, so the international airspace. And in exercising those rights of usage, we should have due regard for all other states. This is a kind of a guiding principle of international law. Okay, back to the Chicago Convention then. So we have also rules over the high seas. It's not that just because no one can claim sovereignty in the airspace over the high seas that there is no law. In fact, there are rules which are set out in the annexes to the Chicago Convention. And in Annex 2, which is called the Rules of the Air, we have a number of rules about how the aircraft operation should be done, how signals should be given, that English is the language of aviation. So pilots are expected to speak English clearly and pronounce in a certain way. They're expected to say Alpha, Bravo, and so on, Charlie, Delta, and not A, B, C, D. Anyway, the point is that in the annexes to the convention, and there are 19 at the moment, there are all sorts of standards, rules. Aviation is a very heavily standardized and standard-driven sector. And that's for one reason alone, that is safety, which is in first place. So airspace sovereignty, as we saw from Article 1 of Paris Convention, Article 1 of Chicago Convention, it is complete and exclusive. So this means that it's all encompassing. Okay, well, take a deep breath, because actually there are some attributes of that sovereignty. In fact, we know that aircraft are flying over, foreign aircraft are flying over in Indian sovereign airspace, and Indian aircraft are flying in over other states and so on. How does that work exactly? Well, it's interesting that it can work at all, because in Chicago in 1944, the parties could not agree on a multilateral, several state agreement to really open up the skies for everyone. And that's because of protectionism. Of course, exchanging rights of traffic rights is a way of making money for a national airline. And so some states, India in particular, has been protective in the past with respect to exchanging traffic rights with other foreign carriers, because of course it wants it to be a level playing field. The former Air India, now invented here, but anyway, had to be protected so in fact, British Airways and Air India should have a level footing, an equal opportunity to compete on the market between, say, Europe or North America and India. And that, of course, makes a lot of sense to us, to our ears today, fair competition and so on. Anyway, the point is that this is enabled, well, first of all, it's disabled, this kind of traffic rights through Article 6 of the Chicago Convention, which says that no scheduled international air service may be operated without express permission. So the airspace, the sovereign airspace, which we've established is so wide and so high roughly, is closed by law, by Article 6. Now, this means that states have to negotiate on a bilateral or multilateral basis to exchange traffic rights. So really, airlines are dependent on states to sit down at the negotiation table and exchange rights and determine how many times a day a flight, an Air India or British Airways flight can fly between London and Delhi. And this is done through air services agreements, ASAs. Now, we did have some success in 1944 through the International Air Transit Agreement, which provides for the parties to it exchange the first two freedoms of the air, which are the freedom of overflight and the freedom to stop for non-traffic purposes. Now, non-traffic purpose is not to unload or pick up passengers or cargo, but to stop and refuel, or stop and have a maintenance check of an aircraft, something like this. So I'm sure you're thinking, well, those are essential. We have to have freedom of overflight. We have to be able to stop in an emergency and so on. So that is not universal, but there's wide coverage of that. It's when you start to pick up passengers and drop them off, or pick up passengers in, let's say, London, take them via India to Sri Lanka, let's say. How does that work exactly? Is Sri Lanka happy with passengers being transported through India? Or would they rather them come directly to Sri Lanka? Or would they rather them come through some other country? So it all becomes rather political, if you can hear, economic, socio-economic and political. The International Air Transport Agreement 1944 was not a huge success. And if you're interested in that, you could Google it and see all about it. Now, Article 7 of the Convention provides that states may refuse to allow cabotage. And again, this is a concept which comes from maritime law. Cabotage is effectively domestic carriage by a foreign carrier. So this would be, let's say, Lufthansa, the German airline I used to work for, Lufthansa operating flights between Mumbai and Bangalore, for instance. Of course, this would not be desirable for Indian Airlines. Why should a foreign airline operate these routes? It will take business away from us. There may also be safety questions about it. We would rather our own airline fly our own citizens and residents. So it is not expressly prohibited, but states have the right to refuse it, Article 7. And most states do refuse it. We also have an Article 8 that aircraft which are capable of being flown without a pilot will not be flown without express authorization again. So that's interesting because already we see in 1944 the vision, the ideas of unmanned aircraft. And it's not exactly clear whether they mean pilot or pilot on board. I mean, when you fly a drone, for instance, of course there is a pilot. The pilot is just on the ground. But there are, through artificial intelligence and so on, there are, of course, pilotless aircraft, which are then operating on a computer sense. Anyway, so Article 8, we need permission if we're to cross borders. If it's a foreign drone, a foreign unmanned aircraft, special permission must be granted first. States also have the right, I should have said that at the start, I'm talking today about the rights of states and the duties of states. So we're still on the rights. States have the right to prohibit or declare as prohibited, restricted, or danger areas. So you can imagine that, I don't know, the airspace above Buckingham Palace, the airspace above Windsor Castle, or above the White House is restricted, right? Prohibited airspace. You may not overfly it for security reasons. So states can do that, but they must make that requirement, that declaration, uniform for all other states. So all states must be prohibited from flying over the White House, not only foreign airlines, according to the convention. Article 89, of course, it was drafted in a wartime, so there's a war provision. In case of war, the provisions of the convention don't affect the freedom of action of any state, whether as belligerents or as neutrals. And the same is true if we have a state of national emergency. So if a state declares national emergency, then we can suspend the Chicago Convention rights and duties from that time. Just looking at my watch. Article 11 is important. That's that point I just mentioned on Article 9 about the prohibited zones. The states must, states have the right to establish certain rules. But these rules must be applied without distinction as to nationality. This is really important because it's the guiding principle, or one of them, of the Chicago Convention, which is non-discrimination and equal treatment. In fact, all states should have the right, the opportunity to compete on the market for air services. And so there shouldn't be any kind of should we say, unfair restrictions on certain aircraft from certain states and so on. Of course, we see in reality that this does happen, but we see it then quickly followed by an explanation. And that explanation is usually something around security, safety, or at least that's what is claimed. Article 13 is also a key one, I think, for us. States have the right to require certain rules or certain procedures are followed with respect to passengers, crew, cargo. So we see this with respect to immigration procedures, passports, customs, and I've just made bold there quarantine, which is something which for a long time we didn't think very much about, but now is a common concept for us, the idea of quarantine. And I think this goes really nicely with the next article of the Chicago Convention, which is Article 14. This is not a duty, but not a right, but the duty of states to prevent the spread of disease through aviation. Of course, we know from the current pandemic that COVID has spread very quickly around the world through people traveling. So aviation has facilitated, in a negative sense, COVID to be spread very quickly to different parts of the world. And so we've seen the reaction to that. And in some respects, the states are pointing to this. They're saying under international law, we have the duty to prevent the spread of disease through civil aviation. That's why we close our airspace, close our borders, or require quarantine measures. Article 16 is just that the states have the right to search aircraft and to inspect certificates and other documents. So again, I'm giving you, the Chicago Convention is typically when I'm teaching this to my students here in Leiden, this is something we spend an entire semester on, public air law. So I'm just giving you a glimpse into the Chicago Convention and trying in a bit to just highlight the key provisions without doing sort of an injustice to this Constitution, not this Constitution, but the Aviation Constitution. So search and inspect. There's the right of the airline to do that. Now, Article 12 talks about the nationality mark, and every aircraft must display its nationality mark. which is quite clear. For instance, in Germany, it's D hyphen, and the Netherlands, it's PH, and Great Britain, it's G, and North America, it's N, and so on, right? So there we can see immediately from that registration, what is the nationality of that aircraft? Not the airline, but the aircraft. Where is that aircraft registered? And that's quite important, because if the aircraft is registered in a state which is not following the standards I mentioned, the SARPs, not living up to their obligations under international rules and agreements, then certain states may say, we will not permit these aircraft to use our airspace. We're afraid they'll fall out of the sky, right? That something will happen on board and so on. So we see a harmonization. These rules are harmonized, whether over the high seas, the international airspace of the high seas, or over sovereign airspace. They are more or less the same rules, or at least the same minimum standards. And that should give us all a little confidence when we fly, because we know that things are being, we have a standard minimum safety level. Okay, we're nearing the end here of my little introduction. We have Article 3. And I think I heard Professor Reggie also talking about state aircraft or military aircraft and civilian aircraft. Well, the Chicago Convention, like the Paris Convention before it, applies only to civil aircraft. It doesn't apply to state aircraft. And we could discuss for a long time what do we mean by state aircraft, but certainly military aircraft are state aircraft. And those used by the state. So if the prime minister, president, or king flies, then it's probably a state aircraft. The point is that state aircraft are referred to in the annexes to the Chicago Convention, because of course aircraft, whether they are state aircraft, military or civilian aircraft, and now increasingly with space launches, they're sharing the same airspace. So of course there needs to be some coordination between state aircraft, civilian aircraft, and now increasingly launches. Article 15 is also quite important. It just provides that if you open your open an airport for use by national aircraft, then it should be open under the same sorts of conditions for aircraft of all other contracting states. Now you could put a little footnote there and say, well, not all airports are capable of providing customs services. Not all airports have passport control or immigration services or customs and quarantine and so on. So states must declare which aerodromes, which airports are customs airports, and therefore, by definition, international airports. The point is that no fees, dues, or other charges can be imposed. No state can impose a cost to enter airspace, exit airspace, or transit over airspace. Transit over territory, rather, transit through airspace. That's quite important because, of course, you do pay something when you use airspace, but it's not an entry fee. Rather, it's a fee that you pay as an airline to the air traffic controllers on the ground, because they are guiding your aircraft. So you have a contract for services there. You get guidance and you pay a fee. That's not the same thing as entering the airspace and paying a fee to use the airspace. The airspace is free. And when we think about environmental protection, emissions and so on, aircraft emissions, this becomes a bit touchy, this Article 15, because it appears or might appear that that some states are requiring airlines to pay something to use the airspace through surrendering licenses to pollute or engaging in market-based measures and so on. So that's another area of public air law. Anyway, states also have the duty to assist aircraft in distress. What is an aircraft in distress? Well, its distress is a condition of being threatened by grave and or imminent danger and requiring immediate assistance. So again, states have a duty to step in, a positive duty to react and help other contracting states, apostrophe aircraft. Article 26, if an accident or incident occurs, then states have a duty to inquire, launch an inquiry. And then it sets out which state should do this exactly. So you can think about the examples of MH370 disappear initially, MH17 shot down, presumably initially. Then an inquiry should be launched, and it should be launched by the state in which this thing happens. And of course, the aircraft nationality, again, the mark, where is that aircraft registered? That state will also want to be part of that inquiry, as will perhaps the US if it's a Boeing aircraft, let's say, as a manufacturer, right? To make sure, was it something wrong with the aircraft? We want to make sure this doesn't happen again. Article 28 states, of course, must also provide airports and air navigation facilities. That almost goes without saying, but this is quite important, as without airports and air navigation facilities, there's no civil aviation. Okay, nearing the end here. Article 33, on the basis of reciprocity, states will shall recognize as valid any kind of certificate of competence, license, and so on that one state, contracting state, issues. So a license for an airline captain, let's say, who is licensed in India, that will then be recognized by all other 192 contracting states to the Chicago Convention. So you have this, there's no need to get a new license if you're starting to fly from other airports and other jurisdictions. Article 37, I mentioned the SARPs before, the standards and recommended practices. There's a whole range of them, as I mentioned at the start. There are 19, but there are things like operation of aircraft, air traffic services, search and rescue, aerodromes, airports, security, so an outside risk, safety management, dangerous goods, environmental protection, which is really at the top of the agenda at the moment. Safety is always there, but environmental protection is really a big thing at the moment, and telecommunications. But it's interesting, are these standards binding legally? Well, they're not treaty provisions, right? They're not in the convention themselves, they're annexes to the convention. And states can file a difference. So if the state practice is different from the standard, the state has a duty to file a difference with ICAO to say that our practice doesn't meet that standard. It's different. That might not be a huge issue, but it's again a duty on a state to report this. And then other states, on knowing this information, may decide to exclude aircraft from that contracting state from using their own sovereign airspace. So that's all found in Article 38. My last slide for you today is just to maybe get you thinking a bit. Article 3 bis. Well, the Chicago Convention, since it was open for signature in 1944, has been amended very few times. But it was amended by squeezing an article between 3 and 4, so 3 bis between the two, in 1984. And this was following a number of interceptions of aircraft, civilian aircraft that were intercepted by military aircraft, and in all too many instances, these civilian aircraft being shot down. Some cases, the passengers and crew survived, other cases, they perished. And so the international community responded to this and came up with this rather, for lawyers, I think we'll agree, rather carefully drafted, understandably, because it's diplomacy, you need to please everyone, or almost everyone. The contracting states recognize that every state must refrain from resorting to the use of weapons against civil aircraft in flight. And that in the case of an interception, so another aircraft intercepting the civilian aircraft, the lives of persons on board and the safety of aircraft must not be endangered. So a few questions for you there. What is a weapon? Is an aircraft a weapon? What do we mean by civil aircraft? Do we mean foreign aircraft, or do we mean our own domestic civil aircraft? And what do we mean by in flight? Do we mean in flight, or do we mean on the ground with the door closed, where the captain is still the lawful commander on board the aircraft? Well, maybe that's some food for thought. I thank you for your time, and I'm open to any questions.
My God, this was extremely, extremely interesting. And, you know, we are already getting comments around how good the presentation is and how much the students are liking it. you know. I have got many questions for you.
I'm sure.
Let's just start. Let's just take as many as we can. So there is one from Anulekha. She is asking, so what happens in cases of a disagreement between two or more contracting states relating to the application and interpretation of the Chicago Convention?
Excellent question. So you've already gone as a good lawyer to, we have a dispute. What are we going to do about it? So Article 84 of the Chicago Convention sets out a dispute resolution procedure. And there have been a number of examples of this. And one in your own backyard, as I might say, is a famous dispute or infamous dispute between Pakistan and India, 1971, where the airspace, Pakistan was restricted. So Indian registered aircraft could not overfly Pakistan airspace, I think at the time, West Pakistan airspace. And you can imagine on a flight between Delhi and Kabul in Afghanistan, a direct flight is 900 miles or something like this. But if you have to go around, all the way around, then you're looking at 2,000 or more than 2,000 miles. So costly in terms of fuel and in terms of time. And plus you get the aircraft, which is not available for you to fly to other destinations. The point is that dispute, and we won't talk about the origins of the dispute, but in aviation, it became a dispute because, of course, the airspace should be open to all contracting states according to the convention, right? We've just seen that today. So in that event, then what happens is India would then approach ICAO Council, and ICAO Council would establish a tribunal, an ad hoc tribunal, and that tribunal would then look at the dispute and give a decision. And if that decision was not agreeable to the parties, then that decision could be appealed to the International Court of Justice down the road here in The Hague. Very, very few instances of this, of cases reaching The Hague, reaching the ICJ. But if you're interested in this, whoever asked the question, or if you have others who are interested in this, a more recent examples is 1999 in the Hush Kits case between the EU and the US, or more recently, the case between Qatar and Bahrain, UAE, Saudi Arabia, and Egypt.
How very interesting. I'm going to take another question. Is the airspace wherein nobody claims sovereignty be governed by the doctrine of common heritage of mankind? Similar to the seas beyond, yeah. Similar to the seas beyond EEZ, Pradyuman Sharma.
Yeah, good question, but this is actually moving upwards to space. Yeah. I mean, the guiding, well, there's a lot of discussion about this, the common heritage of mankind, that space and the exploration of space and so on is actually belongs to all of us. In other words, no state, no private entity, no Richard Branson or Elon Musk should appropriate anything in space. I mean, land or minerals and so on. Of course, they can own the spacecraft and the satellites and so on. That's property, right? But they shouldn't have any rights beyond that. We don't have the same principle in aviation, so no. We use real public international law sovereignty here, based on the Westphalian model of equality of states and all that stuff in the UN Charter. So we're in legal certain hands, I think, with aviation, whereas with space law there is sometimes less legal certainty.
Absolutely. We can take just like maybe one more question. What, in your view, have been the most important outcomes of the convention, the Chicago Convention?
Oh, wow. Most important outcomes of the convention. Well, I think the most important thing is that the convention has created ICAO. And ICAO, let's just be clear, ICAO, International Civil Aviation Organization, there's a secretariat there, which is permanent, right? But otherwise, ICAO is the states. So you have all of these states represented. So it is a forum for states to come together and talk about international civil aviation. And I think that's something really unique. We see it also in maritime law and maritime with the IMO, but there, well, anyway, that's maybe for another day. It's slightly more industry driven, I think, or there are certain states which are really big into shipping by sea, whereas aviation is something which affects us all. Netherlands is a relatively small geographic country, lots of people for the size, people living very close together, but it has a huge aviation industry. Schiphol Airport here has been the biggest or the busiest airport in all of Europe, surpassing London during the COVID crisis and so on. So that just gives you a sense that you know, all states can come together, big and small, and deal with things, and you see success there. So I think that's the biggest, the best outcome of it. And then of course the second thing would be to create these rules, to create, you know, a rule book that everyone plays by, because you can't be a rogue or a renegade in civil aviation. You might at the moment be able to do that in space to some extent, a pioneer, but I think in aviation it's much more rules-based, and that's thanks to the Chicago Convention.
Absolutely. Thank you so much. This has been, yeah, this has been very, very interesting, and I'm sure all the students have enjoyed it. We were not sure, you know, like we were discussing yesterday, you know, this is the last session, and we did not want to delay it. I hope we did not keep you waiting, and I can see the students did not lose interest at all. They were sitting here, they were waiting for a presentation to happen, and I think they have had some good questions. And to all the students who we have not been able to answer, we'll get back to you with all the answers. And to Professor Truxell, it has been a pleasure, absolute pleasure. Thank you so much.
My pleasure. Also, just to say again, I mean, I simply have to say again, if anyone is interested in, if you've done a full law degree to master's level and you're interested to study air and space law here in the Netherlands, or through blended learning, which is a mix of online and in person, then please do look us up.
Absolutely, goes without saying.
Thank you so much, Professor Stephen Truxell. It has been wonderful to, I'm very grateful to you for being a part of this initiative.
My pleasure.
Thank you.
Thank you.
I need to now thank all the students who have been with us through the session. It has been incredible to have you all, and all the professionals also who have been with us through the session. There's just some very important announcement that I would like to make. First is that today's session covered what is the larger scope of aviation in India, and what are the rules governing it on the domestic level, and what are the laws governing it on the international level. Tomorrow we are going to slightly delve into more contractual side of it, what goes into leasing, what goes into purchase transactions, what are the contractual terms, and things of that nature. We will also slightly delve into the Cape Town Convention and how India has ratified it, to what extent has it been ratified, is it even ratified or not. So these will be some very, very interesting topics. Very good speakers are presenting tomorrow, so please be a part of that. All the students should also kindly note that the certificate of participation and internship opportunity will be provided to only those students who have registered for the workshop, and will be posting the link for feedback, which is right on the screen here. So please take your time out for this. And the questions we have not been able to answer, we will try to fill you in once the workshop is over. We are able to compile it, and the answers will be sent to everybody who is registered for the workshop in due course. Thank you so much. It has been a pleasure.